May I permitted to mention for upgraded matter 230 my lord.
Please come on Wednesday.
Witness.
Mentioning for upgradation, please come on Wednesday. Yes.
Your Lordship, because this is that West Bengal premises tenancy matter where the occupational charges can be granted.
What do you want?
Lordship, Lordship had stayed the lower court proceedings that is ending on this month, end of this month.
Extension of interim order. Hand over the slip.
My lord, may I permit, my item number 234.
What do you want?
I am praying kindly take it on today or tomorrow.
Please come on Wednesday. Yes.
May I permitted for extension of interim order.
Extension of interim order.
My lord, for
The subsisting till when it will expire.
30th June.
Hand over the slip.
Mention my lord, I'm paying for extension of interim order.
Hand over the slip.
My lord, I am may I permitted to release this matter. It is wrongly listed in this bench.
Why?
So this is CO 133 of 2024 and it is wrongly listed in this.
Why wrongly listed? What is the error in that?
It is not in your determination, my lord.
Section 24.
Yes, my lord. Yes. Yes, my lord.
Section 24 CPC.
Yes.
To be mentioned tomorrow.
May I permitted to extension of
Lordship, may I be permitted
Please call the list.
mention for the extension of the interim order?
Extension of interim order. Please hand over the slip. Yes, call the list.
May I permitted to mention for inclusion?
Inclusion. Please come on Wednesday.
Mentioning for restoration.
Please come on Wednesday. Yes. Please call the list.
Item number 1.
Your Lordship, I appear on behalf of the
Item number 1, it is for release, my lord. My lord, I am appearing for the petitioner. My lord, the matter was heard by the Honorable Justice Vishnu Chaudhary on two dates, my lord. My lord, the matter was fixed and the notes of argument was
Your Lordship.
called for
If
more.
I may be permitted to submit one thing, there has been no substantial hearing. They have only made a preliminary submission. We have not even started our submissions yet. Your Lordship, kindly hears the matter.
My lord,
And
my lord, kindly have a look of the order dated 26 March, my lord.
only they have been
You are
directed
saying
by
it was
you.
substantially hard. She is disputing that.
We have not even started our submission, Your Lordship.
Yes. What is this matter about?
Your Lordship, it's arising from a Section 34 application, Your Lordship, which has
Yes.
been filed before Barashat Court. Your Lordship, the matter is a commercial dispute and it's a commercial dispute and the judge of the Barashat High Court has transferred the matter to the commercial court at Rajarhat. They have
Is
come
that
from the,
They have come.
yes. The award value is beyond 3 crores, Your Lordship.
This matter was mentioned. Call the next matter.
Well, item number 2, I'm appealing for the petitioner in this case. Well, this is in respect to the custody matter.
Yes.
So we have filed a CAN application, my lord, in respect to, my lord, some modification in
Yes,
respect to the
madam, you have
order.
been paid the balance amount.
For the opposite party, Your Lordship.
All right.
Your Lordship, we want to file an affidavit in opposition
All
to
right.
the to my lord.
File that.
Well, CAN, my lord, only, my lord, before lordship passes any order, my lord.
I'm not
Please-
passing any order. I'm only recording that she has received the remuneration. I'm releasing her.
Well, only two things, my lord. Today, my lord, I have filed an application only to, my lord, bring before the court that, my lord, the mother is
That will
serious.
be taken up for hearing, Mr.
Well,
Chakravarti.
I bow down. Well, I'm not on that. Well, only thing is that, well, each and every week, my lord, well, I'm not against the SO, my lord, it's a personal problem. But the thing is that, my lord, the mother is at sufferance. But today, my lord, only I'm paying, my lord,
After 3 weeks, I've said, because 2 weeks she will file opposition, 1 week for reply.
But this has come for to be mentioned because of the filing of the written notes of argument.
Yes,
My lord, I was appearing on behalf of the petitioner.
yes.
My lord, my written notes, my lord, I have drafted, my lord, could not correct it. My lord, this matter appears subject to, of course, my lord's kind convenience. My lord, day after, my lord, will file written notes. My lord, I could draft it, my lord, could not, my lord, finalize it.
Why it will appear day after tomorrow? Let them file it. Your lordship, let them file it. Your lordship can.
স্যার আমি আজকে একটু বাইরের কোর্টে মামলা করতে যেতে হবে, সেই জন্য বলছি আমি বিকেলটা সময় পাবো না।
After tomorrow,
কালকে নেই।
will be with difficulty.
Day after
Junior can.
no, junior have difficulty. I have also difficulty. I have matter in court number 16. That's the whole trouble.
All right. The written notes of argument filed by the opposite party bank is taken on record. Mr. Banerjee, learned advocate, appearing for the petitioner, prays for 2 days. Wednesday.
My lord has kept it, my lord, day after tomorrow.
All right, Wednesday. List this matter
Wednesday.
on
Grateful
Wednesday
to,
under the same heading.
grateful to your lordship, my lord, grateful to your lord.
To enable the petitioner to file the written.
Lordship, I am attending with the petitioner lordship, extension of interim order till end of the June 2025.
Interim order.
Lordship, my lord, I am appearing for the opposite party, my lord. I apologize for appearing virtually, my lord, due to certain exigency, my lord. At a site,
Initial interim order was passed on 17th September 2024. Thereafter, it was extended 17th December 2024.
What is the impugned order?
Stay
my lord, I have been added as a party in a probate proceeding, my lord.
Impugned order, not the interim order.
Probate proceeding, opposite party filed an application for addition of party that was allowed. Challenging that impugned order, I will prefer divisional application.
My lord, may I indicate, my lord, your lordship, with your lordship's leave, my lord.
Yes, yes.
Yes, my lord. My lord, I have filed an application for adding as a party, my lord. Since, my lord, I am the executor of the, I am appearing on behalf of the executor of the last will and probate, my lord. Last will and testament of the deceased, my lord. My lord, what has happened, my lord, the probate proceeding which is being filed before the Lane district judge and which is being challenged here, the order which is being challenged here, my lord, that probate, my lord, I have joined as a party, my lord, as that will has already been revoked. And after considering all the points and all the such documents, my lord, since my probate application is pending before this Honorable High Court, after considering all the aspects, my lord, the Lane district judge has allowed me to add as a
Yes, call the next matter.
my lord, may I be allowed to file my written objection, my lord, to this affidavit objection?
You need to file written objection to the civil division.
This matter, my
My
lord,
lord, I apologize.
opposite party number 1, I have filed Vokalatnama, and 3 and 4, I will file, my lord. Regarding 2, he is out of station, my lord. C, my lord, it is not possible to.
Some,
I sued for partition. I filed an application for amendment challenging 2 deeds which have been disclosed in the written statement. My lord, my application for amendment has been rejected on the ground that if the amendment is allowed, the nature and character will be changed. As I
Extended for a limited period, my lord, thereafter.
kindly fix it.
Fixed date, my lord.
the learned advocate appearing for the opposite party number 1.
It will appear, my lord, no? It will appear.
Contested application September. That was the direction.
That's true, my lord. If your lordship kindly fix a date, my lord, the matter will
Difficult,
matter, my
Mr.
lord.
Mahato, contested application motions, otherwise motions will not be taken up. That's the difficulty. Let me see how far I can proceed with the motions thereafter. Yes, who is appearing in this matter? None appears for the petition at the time of call. No accommodation has been sought for either.
My lord, 7, can it be pass over for 5 minutes? Mr. Probal Mukherjee is leading us, my lord.
Pass over. Next. For the next matter.
Item number 8.
Item number 8, I am for the petitioner, Your Lordship. The petitioner is the defendant in the suit, and the suit is for declaration. The petitioner prayed for adjournment to apply for the certified copy of the documents that the plaintiff has relied upon. But in spite of that, the trial court has imposed a cost of rupees 8,000 for taking adjournment. And the petitioner has challenged that order before Your Lordship.
Adjournment was granted.
No, Your Lordship. Adjournment not granted.
Yes. Adjournment has been granted, subject to payment of cost. Pay the cost, otherwise.
Well, the petitioner is a departmental latches, Your Lordship.
By the order impugned.
Item number 9.
Your Lordship, I'm for the petitioner. I'm praying for a very short Passover. My senior is in courtroom number 26. He'll be here shortly, Your Lordship.
Pass over. Next.
Item number 10.
Yes.
This is mother for early hearing of the execution case, mother. Now, my lord, kindly, my lord. My plaintiff filed a suit, my lord. Plaintiff is the petitioner. This is a representative suit, my lord, filed by under section 92.
Execution or title suit?
My lord, title number is title suit, my lord, but suit for removal of the trustee. This is a representative suit filed by the.
Yes, so.
Now, my lord, this suit has been decreed.
Suit has been decreed.
Yes, suit has been decreed. Now, my lord, page 25. Kindly come, my lord, page 25. 2006, my lord, suit has been decreed. Page 25.
No, what is this suit of 1 of 2005?
This is renumbered, my lord. This was renumbered.
Yes, but it has been fixed on 6th of May 2025 for hearing of 2 petitions.
Yes. Thereafter, my lord, 6th of May. 6th
Yes.
of May, my lord, previously it was fixed, my lord, on, my lord, your lordship, finally the 6th of May. Thereafter, my lord, matter was adjourned. Matter is adjourned, my lord, 29th October. Now, my lord, suit, my lord, yes, suit was filed, my lord, for removal of the trustee. Filed by the beneficiary.
So what are these petitions? 6th of February 20.
For early hearing. For early, this is the petition.
And what is the petition date? 10th of July?
Both the petition. For early hearing. Your lordship, my lord, I am holding that petition. Now, this has been unnecessarily, my lord, deferred. Regular court, where it was parted before the regular court transferred. Thereafter, my lord, charge court. Third court is the charge court. It was heard. It was also parted before him. Now, my lord, deferred matter is deferred since, my lord, 29th.
This application
Your Lordship, for expeditious disposal of the partition suit.
Yes.
But page 7, kindly see the only the application for injunction is pending for since 2020. My Lord, page 7 of the first page after affidavit portion, Lord.
7th of July has been fixed.
Yes, Lord, this
The injunction application is otherwise ready for hearing or written objection filed.
including the suit, Lord. Ready for
This
hearing.
application under Article 227 of the Constitution of India is at the instance of yes, item number 12, who is appearing?
I am appealing for the petitioner.
Yes.
Appear for the opposite party number 1 and 2 who are on caveat, my lord.
Yes.
The plaintiff is the petitioner in a suit for partition. Ad interim injunction was passed by the trial court. They preferred an appeal. Appeal has been allowed. Ad interim injunction is set aside. Against that matter, I have come. Appeal allows on two grounds. There is two defendants, 9 and 10. They are the state authorities. Appeal court said without leave under section 80, I have filed the suit. Therefore, this cannot be done. This is number one. Number two, there is a will in respect of the properties. There are two schedules, A and B. A will is there. Probate, expiry probate was granted. I want to set aside that is pending. But till now, expiry probate is there. Court said as the probate is there, therefore this cannot be, injunction cannot be done. Two things have been missed by the trial court, my appeal court.
Where is the trial court's judgment?
Last page, your lordship find. But your lordship first take this one.
This is ad interim prayer.
Ad interim prayer. Leave has been granted. Not with leave, I filed the suit.
You have filed the suit with leave.
That is the order. Leave of section 80.
80.
Leave of section 80.
Yes.
That's not the primary ground.
Mr. Shah says that's the ground, one of the grounds, two grounds which
One,
leave.
yes.
One of the grounds is.
It was set aside on merits as well as the section 80 ground.
Yes, so that ground.
That ground I'm not pressing as well. Now, let us seize the trial court's order for, it's fixed for hearing on 7th of July. The temporary injunction petition is fixed for hearing.
You have entered appearance.
I have entered appearance.
So I'm directing the injunction application to be disposed of.
No, we'll
till
file
that
the written
time.
objection within this.
Yes, till that time that injunction will be there.
No, my lord, that cannot be.
All right. Yes.
Since they, let them finish, my lord.
Yes.
Now the grounds is probate is there. I cannot get injunction.
Mr. Shah, please take your seat.
The end is at page
Page 19.
19 from 22, that is there. Your Lordship, kindly before going to that, if your Lordship kindly come to page 38, last paragraph, for once.
No, I'm coming to that. Please let me see. Page number?
Come to page 27.
27.
Then. Second paragraph.
Second paragraph, yes.
They themselves give notices for partition.
No, Mr. Shah, please.
It happened when I'm telling you, Lordship. The will does not cover the entire property.
No. I follow that. There are two aspects. There is, please come to page 31, schedule.
31.
Two properties are involved in the suit for
Yes,
partition.
yes.
It's one is 33 DD Mundal Ghat Road and another is premises number
Regarding
56.
30 Miller, I cannot say for the time being unless property is revoked.
And deed of gift is in respect of which property? There is one deed of gift also.
That is in respect of 46.
That is in respect of
this B schedule, part of B schedule.
So, Mr. Shah, if the deed of gift is not under challenge,
no,
how
deed of
can we
gift in
include
respect of
that
a small
in the
property? That is a respect of a small property, one kata and something.
Maybe, but that cannot be, for that injunction cannot be granted because we have not challenged the deed.
No.
So
Yes,
deed
correct.
cannot be a joint property as on this date as per the amendments made in the plate.
Admitted.
So however specified,
That cannot be part unless this partition is there. That is cannot be separated.
No, the gift deed,
that portion cannot be separated also.
so according to you, that portion is also an unpartitioned one.
Unpartitioned.
No, who transferred by way of the original owner?
Original owner.
If the original owner by way of demarcation transfers, whether the suit for partition is maintainable.
There the schedule is not clear.
Show me the deed of gift.
No, that gift determine the copy. That copy.
Mr. Shah, there are two things. If deed of gift is to be seen for that, whether a specific portion, a demarcated portion, because the sole owner can, by way of a demarcation transfer, or the sole owner can transfer an unspecified portion mentioning the quantum or the share certain part of that. These are the two things. So unless the deed of gift is before the court and you have not challenged that deed of gift, and so the injunction or the suit in respect of which, if it is a demarcated one, then the suit schedule is not specified, Mr. Shah. Injunction may be difficult.
For that period, they themselves ask first, give us notice for partition. Page 27, you also.
Mr. Shah,
this is there. Regarding 30, I cannot say anything.
Mr. Shah,
but I follow your lordship. Our stand is this, that cannot be.
Show me that. Where is your deed of gift?
With regard to my prayer for partition, some portions of the entire property is left but will be enjoyed by all the co-shares.
Give me a minute. Portion, Mr. Shah.
This schedule is not clear. Your lordship make it. Your lordship can make it except the deed of status quo in respect of 46, 47, except the deed of gift. Portion made a deed of gift.
Mr. Shah, please look at the deed of gift. If it is, because prima facie it appears it's a demarcated portion.
There your lordship will not find
because it says that সংযুক্ত নকশায় লাল বর্ণের রেখা দ্বারা বেষ্টিত কম বেশি 1 কাঠা 3 ছটাক পরিমিত. So there is a demarcation.
That plan is there with the deed.
Plan deed says that there is a plan.
Because the copy which
But
is given to, we have shown, plan is
Can you
not there.
please consider this.
Plan is not there, not which I have seen.
I do not, because, but it says in the schedule says, refers to a plan.
You will
Must
also
be- I do not know that plan has been missed or not. Where is the plan?
Probably not with the deed, my lord.
Not with the deed.
Probably not. It's a rather old deed. I'll have to inquire from the client. But there is a plan. There is a plan. I've seen the plan, but
Then give it to Mr. Shah.
let him.
You also must be having a copy of that deed.
But I've same thing I have seen.
They relied on it.
That is why I'm saying that is not properly demarcated. That I have said. So
But see the schedule.
schedule made your lordship, there is measurement is not there.
Yes. Please show it to him.
My lord, they have relied on it in the hearing.
No. Reliance on the deed of gift is one thing, but show the schedule. Next page. Top.
This is not clear. This is not clear. Length, breadth, nothing is there. If the map is there, plan is there, then I am.
Yes, but it appears from
Without plan, it is not.
But
I have seen that.
yes.
Without plan, it is cannot be.
সংযুক্ত নকশায়।
If Noxa is there, then
it's not here. You are right, but
that is why I told you also. These I have seen this thing.
Please ascertain, because otherwise,
Your lordship kindly accept the deed of gift. Your lordship kindly say, status quo accept the
Mr.
deed of
Shah, there are two things cannot be done. If it's not demarcated, then it's the entirety. There lies the problem. If the order will be an infructuous order, not capable of being implemented, Mr. Shah, let us assume, I say, accepting your argument, excluding the deed of gift. Now the deed of gift, if your submission is accepted, that it's also not a specified portion. So then how can injunction be granted in which portion? Then it amounts to the entire, it's also unpartitioned property. It's a joint property. They are only entitled to a share.
Page 35.
Might be Mr. Shah for the purpose of ascertainment of the share. They might be having that portion, the rest portion may be partitioned.
Yes.
That's a different thing altogether.
Yes. That will be done.
Yes.
If
So that's the ultimate thing. But the injunction, how can I say if it's an unspecified one, it's difficult. Please consider that. Or I can directly challenge that.
In 46(1), there is no demarcation. That is our specific appointment in the.
Mr. Shah, one thing can be done. It's the 7th of July. So you are without an injunction from how much time?
Another 2 weeks.
For 2 weeks. 2 more weeks, I am directing because it's difficult.
In the meantime, they change the nature and character or transfer anybody. No, that will not harm anybody. 2 weeks.
Transfer has to be. Don't transfer.
On that reason, I'll submit my concrete terms. There are three, my lord, kindly.
Are you willing to transfer?
No, but there cannot be any order of injunction when the probate has been granted on a demarcated portion. My lord, kindly,
There are two things. Probate, he says, Mr. Shah is not on the probate. He says, but with regard to the other property. Probate is with regard to which property?
Probate is with regard to 30. My lord, the will they have relied on.
I'm saying there are 3 properties. 30, 46 and 46/1. 30 probate covered by probate. 46
you cannot till that
probate is revoked. I cannot say anything.
Yes.
46 covered by probate. 46/1
is also covered by probate.
46/1 also covered by probate. The will page 60. Everything is
covered. Then Mr. Shah, I haven't said anything wrong. I have said 30 covered by will. I have said 46 covered by will. I have said 46/1 part covered by will, not the entire. And 46 and 46/1, there cannot go demarcation. That is a specific allegation.
In the will?
No, practically there is no demarcation regarding 46 and 46/1. And within 46,
bring the will. I am keeping it.
It's 16, my lord.
Will is
they've annexed.
Deed of gift. Please consider that. Heard Mr.
Well, 13, I'm appearing to the petitioner, my lord, challenging the order for rejection of an application under order 6 rules 17 for amendment of the plaintiff. I prepared this instant application, my lord. An impugned order is at page 55.
Yes.
Suit for eviction and recovery of possession.
Amendment rejected.
My lord, amendment rejected.
Amendment of plain.
Amendment of plain. I am for the plaintiff in the.
Yes. What is the proposed amendment? Which page?
My lord, the proposed amendment.
Page 33.
Page 33, annexure D. Para number 2A and 2B I have incorporated, my lord. Starting with an expansion of the earlier facts and the recital that how the defendant have been inducted as a tenant.
No, no. When the
My lord.
original tenant died.
My
The original tenant died
Or the original tenant have died at least 20 years ago, my lord.
20 years ago.
My lord.
Then, so your suit is under 2G.
My lord, I have kept my point open for with respect to the 2G, my lord. My suit is for the eviction of the eviction on the ground of defaulter, damage suit for damage nuisance, and is for the reasonable requirement, my lord. Now I have incorporated in the paragraph 2A and B how the because there was two lease agreement which needs to be incorporated that was not been immediately drafted, my lord, and that despite having an alternative accommodation, they are staying in the suit. She's a married daughter of that particular person who was the recorded tenant, my lord. The recorded tenant have died, her wife also died, and now her married daughter is residing in the suit property, my lord. So I have illustrated that she had already an alternative accommodation that is covering under the portion of the alternative accommodation, my lord. There is a reasonable requirement. I have not changes any chair or any prayer or nature and character of the suit, my lord. It's only an expansion that there was a lease deed which was not been incorporated in my plain. I'll kindly come to my plaint also. That has nothing been drafted, my lord. And my application has only been rejected only on the ground that there is an apprehension. I'm trying to change the character from the tenant to trespasser, but that is not the right thing because I have to opt for a particular position, my lord.
Who is Papia Jadhav? Papia Jadhav is the
daughter of the recorded tenant, my lord. Married daughter.
But her father was the original tenant.
Her father was the original lessee.
If the original tenant died prior to the coming into force of the 1997 Act, she has inherited the tenancy right. That's the recent Supreme Court decision.
My lord, in that event, I have kept all my point of it. It's nothing but kindly come to my paragraph.
How can you, how can you incorporate this pleading that she is a trespasser?
I'm not incorporating this thing. I have just incorporated the fact because kindly come to my plaint, my lord, once.
Fact is, you are saying that she is a trespasser because the mother died in 2021.
My lord, I have not said that. I have said that we have inducted. Kindly
that's your amendment, proposed amendment. Please.
My para 2A, the original Sujata Rani Mollik executed two agreement with Mr. P.K. Mollik in respect of 2 bedrooms, 1 drawing room, 1 kitchen, 2 bathroom. I have expanded the position here, my lord, and covered a garage with for 1,500 and service charges for special fittings and fixtures, and a monthly rent of rupees 7,000 payable to the lessee, predecessor in favor of the lessee.
Kindly come to paragraph 2B.
My lord, after the yes, in the last line, Papia Jadhav is a trespasser.
No, not in the last line. Please start from the beginning of
After
2B.
demise of the said P.K. Mollik, his wife, namely Aloka Mollik, continued the tenancy of P.K. Mollik, and no new tenancy was granted or generated as she inherited the tenancy of her husband, P.K. Mollik, and stayed at the suit property till her lifetime. In the meantime, Aloka Mollik died intestate, but daughter of.
So you have sought to incorporate the fact that the original tenant who died long prior to the coming into force of the 1997 Act, so upon his death, only the wife inherited the tenancy, not the daughter. Now, subsequently, the wife died, so the daughter becomes.
In this is an expansion. Let them give it a. Can be decided at the fair trial, my
no.
Because they have come up with an application under 717 after 20 years.
Yes.
My lord, that will be. This is a thing, and kindly see my paragraph in the 5A also, my lord. That the plaintiff requires the suit property for his own use and occupation. That is already a ground, my lord. My lord, in that event, kindly allow me to permit with the 2A and 5A because that is a reasonable.
Where is your original plaint?
Yes, my lord. And had it been a case that I have served a notice under section 6 and 106 also, my lord.
My lord, kindly come to my plaint, my lord, page 15, annexure P1, my lord. Cause title is like this: Aloka Mollik being died, her heir
Sir,
Papila
have you
Yadav.
seen your paragraph 4 of the plaint? Please read out loudly.
My
Please read out loudly.
this is it was not happily drafted because of some other points.
Plaintiff lab, please read out loudly. Please read out loudly.
The defendant, her husband, and a dog were inducted into a tenancy for residential purpose only, but subsequently the defendant has brought the family of her daughter in the tenancy without consent of the plaintiff. Okay,
It's not
because
plain,
some
sir.
difficult, because this will not succeed. I cannot proceed with this, my lord.
Withdraw the suit, file a fresh
That
suit.
even another thing.
This you cannot amend. This has to remain. You cannot withdraw this, and you have not also sought to amend. So if your submission is that this plaint cannot, this averment cannot go. So please.
Certain things which needs to be incorporated. While kindly come to page para 8 once. Then on 7/4/2012, defendant sent a letter to the plaintiff without referring the said letter, without taking any step for removing the dogs and cats. This is the thing, and this is my notice para 8 that the plaintiff issued 1 month's notice on 15/4/2012 under section 6 of West Bengal Premises Tenancy. Read with section 100.
Yes, sir. Anything more? This application under Article 227 of
In that matter, my lord, I am appearing for the defendant petitioner, my lord. Defendant petitioner, my lord, the instant application has been filed for early disposal of the appeal, which is pending before the
Early disposal of the appeal.
title appeal. Title appeal.
What is the stage of the appeal?
My lord, the hearing stage, my lord.
27th of June.
June, my lord. My humble prayer, my lord.
This application under Article 2. Yes.
No course Premlet for expeditious disposal of the execution application. Millet.
Execution.
18 decreed.
How many miscases are pending?
No miscases pending. Millet.
Under what provision?
They have preferred a millet.
Order 21 rule 1907 to 101. There are two.
They only
two miscases.
No. But they have preferred
fortunate.
they have preferred second appeal millet. Then no step second. Initially it was dismissed for default. They have restored every day millet.
What are the miscases? Where are the miscases?
Miscase
number.
No miscase filed millet.
You said two miscases. I asked you two miscases. You said two miscases. Order 21 rule 97. You said yes.
No.
Execution.
Execution is pending. And it is being adjourned only on the ground that second appeal is pending.
Second appeal is pending.
Since 2023 millet. Every day.
Serve a copy upon the other side. Let me see whether the second appeal can be expedited. Ashun. The learned advocate.
Number 16.
The defendant, my lord, is the petitioner of your lordship in a suit for eviction on the ground of default reasonable requirement. Lord, ex parte decree was obtained. Thereafter, my lord, I filed an ordinance rule 13. That was allowed.
7172 rejected.
Yes. 7172 rejected, 73 allowed.
That's the consequence.
Although I filed it within the statutory
What is
period.
the ground on which it was rejected?
Rejected because they show that out of time I have not complied with 7.1. A few dates are very important.
7.1 you have not complied with.
As per the court. I say I have complied. Few dates are very important.
Initially there was an ex parte decree.
Ex parte decree.
So you appeared, that was set aside.
Yes. I was directed to appear. So, my lord, the previous proceedings takes a back seat. The first date of appearance fixed.
When the ex parte decree was set aside,
Lord,
when you entered appearance.
Ex parte decree was set aside on 29th of May 2023.
29th of May 2023, ex parte decree set aside.
Set aside, and direction was given for my appearance on 30th of June 2023.
30th of June
2023.
Date of appearance.
My lord. So, my lord,
and you entered appearance when?
On 30th of June 2023.
And when you filed?
24th of July 2023, I filed my 7172.
24th of July.
My lord. And from 3rd of August, I am depositing my admitted arrears along with, my lord, with court.
Mr. Kormokar,
my lord.
What is the stand in section 7.2? What's the dispute
Lord,
you have
I
raised?
say that during the pendency of that, Lord, period, when I was, my lord, contesting ordinance rule 13, an occupational charge was imposed upon me. So, my lord, I deposited that money. Now, because I won the, my lord, that case particular, this, my lord, decree was set aside. So, my lord, in such a situation, I am entitled, my lord, to get back that occupational charge. I say, adjust it with my previous arrear. The remaining is my due. I have deposited that amount.
You have deposited the along with 7.2.
7.1.
7.1.
Yes. Lord, kindly comes to page 44. Kindly comes to page 44.
Show me the finding. What is the reasoning of the learned?
Lord, kindly comes to. Lord, kindly comes to the second page. Peruse the petition, the challans, and the case record. Thereafter, on perusal such and I'm sorry.
The Kormokar, whether a direction to pay occupation charges can be said to be rent.
But I don't say that is a rent.
So
I say
adjustment,
the money is
so,
there.
So that was Mr. Kormokar, that was a condition for stay of the execution.
Absolutely.
So whether you can say that please adjust it with the rent.
That's a dispute under 7.2 that has to be decided. Kindly comes to page 40. This is my dispute that I have raised. The first column, that is not the admitted rent that is due, interest thereon comes to 11 lakh such and such. Thereafter, compensation that I have paid for occupational charge 7 lakh such and such, security money deposit 72. I say after the adjustment, I am liable to pay 62,222. Now, Lord, kindly turns over to page 40.
62,292.
No, 62,222.
Not there is 2 has been struck off and said 9. All right. 222 or 292. So you have deposited this amount.
Kindly comes to page 44.
44.
Yes. My admitted amount deposited.
No, that was when did you deposit that?
3rd of August. Your Lordship.
Not along with 7.2.
Lord, 24th of July.
Yes.
Within that period, Lord, 24th of July, I appear. I file that.
30th of June, you appeared.
30th of June, I appear. 24th of July, within 1 month,
Yes.
So, my lord, within 1 month, I filed the application.
File the application, but you did not
Yes.
deposit the admitted arrears.
This, your lordship knows, my lord, usually until and unless there is a direction from 7-1, I am not permitted. This I made out of my own volition.
This which court?
Even then.
This is which court?
Alipur.
Alipur is not maintaining that. That's the problem with Mr. Kormukar. That's the problem with City Court. Now it has been taken care
Even
of.
then, I am covered by the proviso.
No. So not
Even then, I am covered by the proviso. 2 months from the date of appearance.
So you have not deposited along with that.
But within that proviso period, I have done. Kindly considers that. Within that proviso period, I have done.
No, Mr. Kormukar, if you have filed that application, you are obliged to deposit the amount on that date.
My lord.
You are obliged to
I bow
deposit the
down. Lord, at the same time, if I have not deposited that particular amount, Lord, within the proviso period, if I deposit, Lord, that has also to be taken into consideration. It will be treated.
There is substance in the argument.
Part 17.
Lordship, this is my application for expeditious disposal of the execution case and the application pending therein, Your Lordship.
The execution cases of the year 1998, Your Lordship.
How many miscases are pending?
Nothing is pending, Your Lordship.
No miscase.
There has been an order of attachment, which was allowed in 2013. In 2014, I filed an application praying for a sale of the attached property by
This application under Article 220.
Miller, I am for the petitioner, Miller, who are the defendants in the original suit, Miller. Miller, first of all, I must submit before your lordship that the suit is not still not mature, Miller.
Thank you, sir. So,
my lord, but the kindly see, my lord, the suit was filed in the year of 2001. And today,
unless
my lord, kindly give me one.
Unless the suit is ready, no directions for
My lord, the litigants are suffering. My lord, 25 years.
So you have to take steps, appropriate steps. This application, you have
Item number 19.
My Lord, for the petitioner. My Lord, this is an application of expeditious trial of matrimonial suit which is pending before the learned.
Who are you, madam?
Well, I'm for the husband.
What happened to the miscellaneous case under section 24?
My Lord, it was set aside by this honorable court, and that it was amended back to the trial court, and also it was dismissed.
It was dismissed. Miscellaneous case. Where is that order?
Not annexed, my Lord. My Lord, your order was annexed in page number 38.
Page number?
38, your lordship's order.
Yes, there was a direction to dispose of the miscellaneous case expeditiously. What happened after that?
My Lord, it was dismissed after that.
This application This matter.
Matter number 20. May it please, our defendant is the petitioner before your lordship. The plaintiffs and the defendants are the two brothers. Now, the plaintiff.
Why are you fighting then, Mr. Rai?
Yes,
was
I
there?
am also asking myself why the plaintiff is fighting this suit. Plaintiff filed a suit for eviction of licensee against me. Now, the suit decreed. I have preferred an appeal. An application for stay was preferred. The learned judge directed me to pay 5,000 rupees per month as occupational charges.
Since you have suffered a decree, eviction of a licensee, conviction, what is the area of occupation?
Similar PR I have made before your lordship sometimes ago. Now, your lordship negated my PR. Now, I am supplying, preparing a judgment of this court, of the division bench, where it is said, for eviction of trespasser or licensee, no amount can be asked for. Paragraph 20 and 28.
That was Mr. Rai in the prayer for temporary injunction, the plaintiff prayed for eviction. So now it decree has been passed. Decree has been passed.
Yes.
So this
Now, but it is against an eviction of licensee. I have already filed a suit for declaration that the deed executed by my father. The father was the original owner of the property. Now, since I was ill.
When did you file that suit, Mr. Rai? After the decree has been passed. After the decree has been passed.
Then maybe, but
I can do one thing, Mr. Rai, I can expedite the appeal. That much I can do.
But you lost eviction of in eviction.
What is the area you are occupying, Mr. Rai?
Mr.
Rai, till this.
Your lordship kindly see the paragraph 7 of the plaint and
what is the area you are occupying? How much area? Where the property is situated?
Is that Kosba, Bushpukur.
What is the area?
Area
means
not,
extent
area
of
is not,
occupation.
area is not mentioned. Kindly peruse paragraph 7 of the plaint.
Paragraph plaint is not here. Entire first floor.
Area is not mentioned. But
maybe. First floor, Mr. Rai, if you can get a property less than 5,000 in Kospa, you can.
No, that's a different thing altogether. But
Mr. Rai, 5,000 is a reasonable amount.
The principle says the eviction of I have the I have the share also in the property. But
Mr. Rai, the problem is till now the deed of gift is there.
Yes, that's
and
true.
you have filed a suit after the decree has been passed.
That's
so.
That's true. But 5,000 rupees.
An object.
The decree was passed. I was ill. I was working in a government concern. Because of my illness and my insanity, my service has been terminated. Now, I am staying with my wife and daughter, who is a school-going children of class 7. I do not have any income at all. I do not at present. I do not have any income at all. I have lost my service.
Sympathize with your client, but when it comes to the law point, it's difficult.
In case if I am a regular tenant and I have been evicted, that's I could have understood. But since this is an eviction license,
I think Mr. Rai, you are opposing me in that matter. In a New Alipur property, eviction of a licensee, I suffered an order.
Just now I can't remember, but few days ago I moved.
In that matter, Mr. Shivashish Ghosh was appointed as the, or Mr. Ghosh was my other side.
Maybe, but few days ago I made a similar prayer.
If I bring my senior to argue in that matter, Mr. Dasgupta was leading me. The amount will increase.
No, few days ago I
remember.
On behalf of
the plaintiff, for eviction of a licensee in a New Alipur.
Few days ago, on behalf of the plaintiff, I prayed for similar relief. lordship, and your lordship says I am expediting the suit, but in a suit eviction of
That
licensee.
was, Mr. Rai, I remember that. That was prior to the passing of the decree. If after the decree has been passed, Mr. Rai, it's difficult. I remember that. That's New Alipur property. Applying the decision of Jagad Narayan Singh.
Maybe my lord, just now I can't remember, my lord. But
So I suffered an honor. And I was asked, if you bring your senior, the amount will be further increased. Ashok, this application
One matter, item number 7,
এই পাসওয়ার্ড পরে ডাকবেন
21.
ইয়েস
Your Lordship, I'm praying for a short Passover.
ওয়াই
Lordship, the learned advocate is engaged in some other court.
all right পাসওয়ার্ড yes next
Your Lordship.
Item number 22.
The plaintiff is the petitioner before your lordship in a for partition, my lord. Initially, my lord,
Proposing this up.
that initially, my lord, the preliminary decree passed. Thereafter, the partition commissioner's report was accepted, my lord, challenging that ex parte, challenging that I filed, my lord, an appeal. If your lordship takes up, my lord, the page 48 of my lord's brief, the appeal allowed, my lord, remanding the matter back, directing my lord, the learned trial judge to take up my objection with regard to the validity of the commissioner's report, since that was also done ex parte according to me, and thereafter to decide, my lord, the final decree. So this is the order of remand. Thereafter, my lord, I came back before the honorable, before the learned trial judge, and I tried to adduce evidence in connection with deciding my objection to the commissioner's report. That was again turned down. Challenging that, my lord, I came up before this honorable court. My lord, coordinate bench of your lordship court, my lord, have decided, page 50 of my lord's brief, that considering, my lord, the tenor of my objection, I should be allowed, my lord, to adduce, to rather recall my own witness to show before the learned trial judge that I was never being, my lord, served with a copy of the, my lord, notice that the commissioner will conduct, my lord, the inspection at the site in question. That is one of the grounds by virtue of which this honorable court directed, my lord, this recalling of the plaintiff's witness will be done. Another, my lord, Shibu is,
you are the defendant,
I am the plaintiff.
you are the plaintiff.
I am the plaintiff. So no notice with regard to, my lord, the commissioner's, my lord, inspection. For that reason, my lord, I have been allowed to recall my own witness, as well as I will be, my lord, granting the Shibu. My lord, Shibu has been shown in the report that he is as if the authorized representative of me. I say he is not my authorized representative. For that two ground, my lord, this honorable court allowed this exercise to be done. My lord, page 52, your lordship kindly takes up point number 9. Page 52, my lord, the order, I am not, my lord, placing
Yes.
the entirety. Point
Yes.
number 9, if your lordship, my lord, may I place? This court cannot prejudge such contention of the petitioner. However, when a specific objection with regard to the Shivu's presence and authorization had been raised in the objection of the commissioner's report, and the honorable division bench had permitted the petitioner to agitate his objection and had further directed the learned trial judge to hear out the objection for the ends of justice, the petitioner must be allowed to recall himself, adduce evidence, and produce Shibu as a witness with regard to such issue. The evidence shall be restricted, that I am not traveling, my lord. So this, on this court,
Show me your objection to the commissioner's report.
objection টাকে annex করেছিলে? My lord, kindly takes up, my lord, page 41 of my lord's brief. entirety, my lord, it has been, my lord, elaborately it has been taken. Firstly, no notice.
Give me a minute.
My. Lord, yes. Yes.
Show me the evidence of the commissioner.
The evidence. Because, my lord, this after a cross-examination, when I applied for further adducing evidence, for recalling my witness and Shibu, that was allowed by the
Mukherjee, where is the scope of further giving evidence?
Lord, in my respectful submission, Lord, that is a closed chapter. Lord, this honorable court, Lord, coordinate bench decision, Lord, is there. Lord, they have not challenged also.
Where is the provision under the law? Show me.
Lord,
for your giving evidence, you can cross-examine the partition commissioner.
Lord,
if there is any
Lord,
defect in the
kindly
commission work,
consider, Lord, it is not about my case, because paragraph 13, your lordship already noticed, Lord, my written objection.
your
my
written objection is that you are not present. The commission work was done in the presence of the defendant number 1 and his advocate, and only a security personnel was present whose name is Shibu. So pure and simple, according to you, it was an ex parte commission work. So you could have cross-examined the commissioner on that issue. Where is the question of producing whether Shibu was your agent or he was not agent for the purpose of proving that?
Lord,
What is the scope for leading further evidence by you?
Lord, there is no limitation also. Lord, that I cannot.
Mr. Mukherjee,
Lord,
it's only. Please come to Order 26, Rule 13, I think. 13 and 14. So it's you can file an objection. The court, after hearing, will consider either vary or modify and pass a decree. So you can cross-examine the commissioner. Where is the scope of giving you liberty to adduce evidence? What for? Because Mr. Mukherjee, it's only the commissioner report which you are challenging. You are saying I was not present. You have to cross-examine the commissioner on that.
In the commissioner's report, Shibu has been shown to be authorized by, not on behalf of me, he has been authorized not to present over there.
Yes.
But Shibu is not my authorized agent to show that before, because it is in the report, it has been shown that Shibu as if I have authorized him. Until and unless I call the Shibu on doc and show before the court that there is no authorization on behalf of me to Shibu. Rather, she is
whether notice of commission was served upon you.
No, that is my paragraph 13 of my objection kindly looks at.
But even then, even accepting, you have to stand or fall on that. You have to cross-examine the commissioner on that issue that you are not served. The commissioner has to show that. So the commission report, where is the scope of again giving you, you will go and prove whether Shibu was your authorized agent or not, actually enlarging the scope of this.
But kindly see here, paragraph 13 once. It is not about a simplicity that notice has not been. There are allegation and counter allegation with regard to the communication in touching to the learned advocate also.
Your learned advocate. What steps have you taken against the learned advocate?
No. That is the allegation of the commissioner. That is the commissioner.
Show me the commission report.
Commission report is also. Commissioner's report is at page 27 of my lord's brief.
Yes. Show me with regard to that service of notice.
Page 29, point number
29.
Yes. That after receiving the writ notice served upon the defendant number 1 through his learned advocate, and notice served to the plaintiff and his learned advocate through registered post, but learned advocate for the plaintiff and also plaintiff refused the notice that the defendant number 1 learned advocate supplied the copy of the plaint petition under order 26 rule 13 of CPC.
So Mr. Mukherjee, that was only the scope of inquiry.
Yes, that's why.
So whether, let us assume that this service is not proved.
Actually, I am not in the other way of other round of litigation. When I was really facing this, there was a problem with regard to the postal envelope, which my client wants to tender evidence. That's why he wants to recall. I have shown that before the coordinate banks that there is a dispute with regard to the postal envelope and that refusal column. That's why to tendering that my client wants to put on doc. That is one aspect, and Shibu's authorization for that Shibu. That's why this honorable court restricted it.
No, that point, Mr. Mukherjee, you could have put that question to the commissioner. Mr. Mukherjee, the commissioner says notice was served. He has to prove. You can cross-examine with regard to the service. On that, you are cross-examining, you can put your case in cross-examining to the partition commissioner. For that, you need not come to the dock. Cross-examination is for that purpose. Your sole contention is that you are not served with the notice.
Not only that, but there are other points
the
also.
Notice,
Yes.
You can cross-examine where is the necessity for your coming to the dock?
There was an envelope problem. The envelope is with me.
I appreciate that. There was an envelope problem. So that question you can put in cross-examination.
But rightly or wrongly, this has been once directed to be done. When I file, what happened? The real problem remains what is the subject matter of the present revisional application.
Now, what is the impugned order?
After both of the order, first takes up 10th December order. Yes. What happened, it is my advocate, when he has tendered the examination in chief, there was a discussion, there was an argument before the
court. So you are directed to adduce evidence at 3 p.m.
That's where there lies the problem. At the very beginning, in the morning, at the sitting of the court, my lord, there's a hearing took place with regard to the scope of this, my lord, examination, because this honorable court directed this exercise to be done with a limited purpose, only to give, my lord, certain window, my lord, open, that you have to restrict yourself to to examine and cross-examining within this narrow scope. So my not examination in chief, according to the learned judge, was not as per the direction of this honorable court. So a hearing took place. Ultimately, it was never directed, my lord, by you in open court to take up the matter at 3 p.m. Your lordship knows, your lordships today, my lord, there is a possibility, my lord, of even uploading of order, my lord, in course of the day. But before the learned trial judge, there is nothing. But this was not posted or informed to the learned advocate that
So your evidence was closed.
I filed a 151 application. Since this point I cannot take up in revision, I filed a 151 application, my lord, stating everything, that this was not informed, never informed to us that the matter will be taken up at 3 p.m. So on that same day. But, my lord, the learned judge, again, my lord, my recalling application is being rejected, holding that I have not challenged the initial order of 10th December by filing a revision. But law is that, my lord, I cannot.
Where is that?
My lord, kindly takes up, my lord, the last order in the challenge. My lord, kindly takes up, my lord, the second page of the order dated 5th of June 2025. My lord, the middle paragraph starts with at 3 p.m. Second page of the order
page, yes, at 3 p.m.
Yes, at 3 p.m. the plaintiff learned advocate was not found present in the courtroom, and it was observed by this court that due to the reluctance of the plaintiff to adduce his evidence as per the direction of this court, the evidence of the plaintiff stood close and on such and such was fixed for argument on the point of acceptance of partition commissioner's report. It is further appears from the case record that till date the plaintiff has not challenged the order dated 10th of December 2024 before the Higher Forum. It is once again pertinent to mention here that the Honorable High Court in CO number such and such by order dated has directed this court to hear out the objection for the ends of justice with an observation that the petitioner must be allowed to recall himself, adduce evidence, and to produce Shivu as witness with regard to such issue. The evidence shall be restricted to the contention that Shivu was not authorized. Lord, I am skipping this part. Kindly turns over the page. Therefore, in view of the specific direction of the Honorable High Court at Calcutta, the examination in chief dated such and such filed by the plaintiff appears to be in total contravention of the direction of the Honorable High Court. And
What is your examination in chief?
There you go.
পার্টিশন কমিশন এক্সামিনেশন চিফ ফর ওয়ান প্রিন্টিভ আমার
কিন্তু এটা তো জুলাই, আমাদের হাইকোর্টের অর্ডারটা কবে হয়েছিল?
আমার হাই
হ্যাঁ, ঠিক আছে,
ওটাই
বলেছি লাইট হবে যা আছে সেটাই আমার করা না। ঠিক আছে, আমি সব চাইছে দেখো।
Rightly held.
That, in my respect to submission, that can be done on that very day. Had it been a case that court has turned down my prayer.
Started from file the original deed of sale and that thing, everything. It was a restricted evidence.
Allow me to do that. Allow me to do that itself. The court has never, considered this aspect. While I gone there to recall that order, the court gone into the merits. But seeing this, the court has allowed me on 10th of December to take part in the examination at 3 p.m. as per the court's order. My total endeavor, is to
delay,
hold the commission.
Total endeavor is to delay.
Kindly see the report.
From
there
the
are lots of room that has
from
been
the Mr.
recognized by the learned.
From the tenor of your evidence in chief.
I being the plaintiff, why, I will, may I ask this question to myself?
There may be very many reasons. So, because your evidence was restricted only to that, and see the affidavit in chief of 4-5 pages.
Allow me to do that itself.
Yes, what do you say?
I cannot,
Only, my lord,
enlarge that.
two things, my lord. If your lordship sees the order of the division bench, my lord, when the first time when the matter came before this honorable court, my lord.
Yes.
The division bench was very specific. My lord, I consented that let there be a contested hearing, my lord. I consented to that, my lord, because an ex parte, my lord, an ex parte, my lord, was passed, or an order of ex parte was passed against the, my lord.
Where is the division bench order?
My lord, page 50.
48 and
Starts from
49.
page 50, my lord.
50.
At a single bench, no, double division bench, no, at a division bench. 48, my lord, 48.
48.
48. But that order was passed on 6/10/2023, my lord. Kindly see the date of the order. 6/10/2023, my lord. My lord, Mr. Wasim Ahmed, learned counsel, appearing for the respondent on instructions from his client, fairly submits that the order impugned in the instant appeal may be set aside.
Mr. Mukherjee's client was the appellant there.
Yes, my lord.
Plaintiff appellant.
My lord, there was a specific order, my lord, of the division bench, my lord. If your lordship sees the 1, 2, 3, 4th paragraph of the second page of the order, we also made it clear that the court shall dispose of the partition suit by passing the final degree within 4 weeks from the date of reopening of the trial court following the puja vacation. The time limit given herein above is peremptory and mandatory. So within 4 weeks, my lord, the partition suit by passing the final degree within 4 weeks, my lord, that was the time limit given by the division bench, my lord. Then, my lord, they come up with another revisional application on 1/4/2024, my lord. An order was passed on 1/4/2024 by the single bench, my lord. And in that case also, my lord, and a specific order time limit was there, my lord.
Mr. Ahmed, the specific order may have been done. Then why did you not bring to the notice of the coordinate bench when this was the scope was very much limited?
My lord?
The scope was very much limited of the remand. And
But
that was
remand
enlarged. You have accepted that.
And remand was done only when it was the ex parte order was passed against, my lord. That final degree was passed ex parte. So I said, my lord, on that consent, my lord, consent.
What do you say to this? Thereafter, they have sought everything, reopening, they will give evidence. Another person will be brought into evidence, and you have accepted that order.
But unfortunately, my lord, the question raised by your lord,
that order.
the question raised by your lordship, my lord, I had raised the same question, my lord, but unfortunately that was not taken into account, my lord.
Accepted that order.
Now, my lord, kindly see the conduct of the petitioner, my lord. The conduct
What can be done now?
My lord, this has been going on since 2023.
You are bound by that order, my
No,
son.
I'm
You are also bound by that order.
bound to that order, my lord. But since this has been going since 2023, my lord. An order, specific order for disposal of the final degree to be passed in the partition will be for 4 weeks, my lord. But that period, order was passed in the year 2023. Now we are in the year
Cannot be done
2025.
now. The manner in which it is proceeding.
But if they don't appear, my lord, if they don't appear,
What is the next
court-
date fixed?
My lord, I don't know, my lord. Next week, kabe achoda? 18/6.
18 June, my lord, was the last date.
18 June চলে গেছে।
Next date, my lord, I have. দেখতে পাবেন?
Mr. Mukherjee, I will have to record your submission that will restrict your evidence with regard to only that part.
Your lordship has to, my lord, because
No,
I cannot enlarge.
But why have you filed this affidavit in chief?
Sometime, my lord, something, my lord, your lordship knows, my lord, even, my lord, with saying, my lord, they will not do. They will try to, my lord, why why, my lord, this entire exercise.
If required, file an affidavit that will restrict to that.
My
You
lord,
will not
entire exercise, why, my lord, I have now, my lord, point out.
ask your client to
My lord,
file an
to every
affidavit.
date, my lord, the learned.
Which portion of the affidavit in chief you will restrict? Please indicate that by filing an affidavit here.
But as per the order of the coordinate bench, my lord,
No. But you have not filed the order. Then this is to be set aside.
my lord,
This cannot be accepted.
I will file.
Either you say
I
which
will
portion
file
of the affidavit.
My lord,
in
kindly
chief.
direct me to file a rectified affidavit in chief, restricting what is the ambit and scope of the coordinate bench order. Lord, direct me that. Lord, I have in the the counterpart of the court below, I have, Lord, numerous occasions stated that please don't, Lord, enlarge the scope whatever has been allowed by the coordinate bench. But times and again, why this my witness, I have now, it has been come. The two of the notices was being served to me by the commissioner, giving a date of inspection. But ultimately, the inspection has been held in a prior date.
Mr. Mukherjee, all these things for that, you are not
Questions
required
were
to
never
give
put
evidence.
before the advocate commissioner.
Could have cross-examined
Never-
the
never
partition
cross-examined.
commissioner then and there.
Never
That will be the end of the matter.
This document,
Only
Yes, can you not controvert with that those documents?
we can always.
At the time of cross-examination, then you know all the procedures, Mr. Mukherjee. Evidence on that date. Please take his. Mr. Mukherjee, ask your learned junior to take instructions when is the next date fixed. I will, because I will allow them to give evidence on that date. You cross-examine on that date itself. Mr. Mukherjee, you have to ensure that your witness will be present as well as Shibu
on that day.
Yes.
Both.
And evidence will be restricted to only that.
Yes, yes.
That only that.
This application under Article 2 Yes, Mr. Chatterjee.
Please, Your Lordship. Lord, the defend numbers 2, 3, and 4 are the petitioners before your
Order 7 Rule 11 rejected. You have become an expert in Order 7 Rule 11, Mr. Chatterjee.
I am expert in nothing.
70% matters are Order 7 Rule 11 rejection.
I am expert in nothing.
No, expert in all, but this is a special expertise in Order 7 Rule 11.
It's just a Lord.
I'm not saying that you are not expert in other fields. It's a special expertise in this.
No, not at all, my Lord.
Yes, Mr. Chatterjee.
My problem is, my Lord, the suit is valued at 300 rupees, where they have themselves said that the assets which are, my Lord, the subject matter of the suit is worth, my Lord, 3 crores 35 lakhs. Now, forgets about Order 7 Rule 11, my Lord, it will be hit under Order 7 Rule 10 as well. Because Section 7(3).
Mr. Chatterjee, for that, valuation has to be first a decision on the valuation.
Absolutely. I
has
bow
to be
down.
made.
I bow down. The court
So
could not
you
have
file an
proceeded.
application, I think, under Section 11.
I did not file it under 11 because they have already admitted the amount. They have themselves said.
But there has to be a court's finding on that, Mr.
That is where I am before your Lordship. My Lord, I want the court to find that. The court has gone, my Lord, in a
Unless
direction.
there is an application, Mr. Chatterjee, how can a
My Order 7
decision-
Rule 11 application is there.
Order 7 Rule 11 does not say so. Order 7 Rule 11.
First, there will be a.
Yes,
So
then
that is.
court fees and other things. So it's
That
the
cannot. My Lord,
it's at the
if
premature stage.
The court.
Order
will-
7 Rule 11 is at the premature
My Lord,
stage.
I am saying it is the duty of the court first to see whether it has jurisdiction or not.
For that, some application, some material.
This application was there. This
Where is that?
application.
So I'm directing that application to be decided.
So that application under this application under Order 7 Rule 11.
That cannot be done, Mr. Chatterjee. That cannot be done. You have to file because Order 7 Rule 11. That is, I think it's the
I
premature.
say Order 7 Rule 11 says that if the court has asked them, my Lord, to has come to a conclusion and asked them to
Where the relief claimed is undervalued.
Yes.
And the plaintiff on being required by the court to correct the valuation.
I'm on the second part.
Yes.
So this is
So
a
when
part
is the
of Order 7 Rule 11.
No. Thereafter, if he fails to do so.
That's exactly what.
So,
My Lord, this is under Order 7 Rule 11. So I am
there
saying
has
the
to
court
be-
has to go into that part, below the second
not in
part,
Order 7 Rule 11.
7 Rule 11. Under Order 7 Rule 11.
Mr. Chatterjee, unless there has to be an adjudication.
Bow down.
So there has to be a prior adjudication
done under Order 7 Rule 11.
I think in Suit Valuations Act Section 11 or 12. I think
Section 11 is a different thing altogether.
so. That is the valuation of the
There is
suit.
no dispute.
So that has to be.
There is no dispute. No. Can you have a look at Section 11 once? There's no.
Where is that?
একটা copy. Hey, রৌনকের কাছে ছিল। রৌনকের কাছে ছিল। দেন একটা। না, খুব রাগী লোক। তারপর আমাকে গালাগাল দিয়ে দেবে।
Inquiry as to valuation of the suits.
Yes.
If the court is of the opinion that the subject matter of any suit has been wrongly valued, it may revise the valuation
Correct.
and determine the correct valuation and may hold such inquiry as it thinks fit. So, Mr. Chatterjee, it may also contemplate some inquiry to be made.
Very
There may
well.
be certain cases where without inquiry, the valuation.
Bow down to your lordship as always. I am on a different aspect altogether. My lord, here, if the court is of the opinion that the subject matter of any suit, so no application is required. Suo moto. It is the duty of the court.
Mr. Chatterjee,
there is-
accepted, but the attention of the court is to be
Drawn to a
That is usually done.
I'll tell you.
By file an application.
show your
Show me that you have
I'll
said
show your
that.
lordship the attention. Kindly turns to the Order 7 Rule 11 application once. And kindly turns to my lord paragraph 3, page internal page 3 at page 79.
79.
This is the attention of the court. Seize my lord paragraph 3. I'm not reading for
Mr.
you.
Chatterjee, your application has been rejected. So I will direct the court to treat it as an application under Section 11 and to consider that issue. Yes, Mr. Chaudhary. This application under Article Closed off.
Modified to that extent. Modified to that extent.
Modified?
To that extent. The impugned order.
The impugned order stands modified. That to be treated as. Because Mr. Chaturvedi jumped up when I have said it's restored.
Lord, when Mr. Chatterjee is on the other side, I am only apprehensive of tricks, not of law.
Money?
Yes.
I don't know whether that's a compliment or that's a slap on the face. I have really no clue.
That's your reputation which you have earned.
No, it is not a criticism. It is a compliment.
Reputation I have said.
It,
Reputation which he has earned.
I give it as a compliment. In civil practice, it is a compliment.
Yes, call the next matter.
This is called COPA.
Yes, call the next matter.
In item number 24, Lordship, I beg to appear on behalf of the petitioner, Lordship. There is no caveat pending. My prayer is that, Lordship, for expeditious hearing of a matrimonial suit, Lordship, it was initiated and filed before the Family Court Ajnala in the year of 2023 in the month of July. And subsequently, Lordship, the respondent wife has preferred an application under section 24 of CPC before the Honorable Supreme Court. Subsequently, the matter was transferred. And then he entered into this application. Lordship. Since then, it was pending. It was transferred to the district judge of Jharkhand, and subsequently there is a family court has constituted, and now it is pending before the family court. Now, Lordship, earlier occasion they have filed the written statement, and subsequently, Lordship, that matter was fixed for the evidence. But although law is not permitting for the fix of evidence, subsequently I appeared, Lordship, and then after it issues for
any alimony application has been.
No, there is that alimony application connecting to this case, Lordship. They have filed a DV Act. DV Act is pending, but no alimony pending is over there, Lordship, in this matrimonial suit.
This application under article, what is the
Lordship is framing of issue. In earlier occasion, they have fixed for evidence, but then after
framing of issues.
Framing of issues, Lordship. But
what is the next date fixed?
Next date, Lordship, 2nd of July. 2nd of July 2025. Lordship will find from the annexure the certified copy, Lordship.
2nd of July for framing of issues.
Framing of issue, Lordship. Although the matter was filed in the year of
this application under article 220.
Time may be framed, Lordship, because from the 2023,
all matters, expeditious hearing, no time can be fixed.
25, I am appearing for the petition.
Yes.
Application, one applications under order 11/2/21 was filed. But that application, my lord, the court has rejected it only on the ground that this cannot be treated as a right.
This cannot be treated
as lightly. My lord, the court kindly turned to page. Court has observed that they have not filed the document as required, as directed. But the court on the other kindly turned to page 3. My lord, it is well settled that stringent provisions of order.
According to you, the defense is to be struck off.
The defense is to be struck up for the failure or, my lord, in the alternative.
Why are you trying to, Mr. Why are you trying to delay your suit? Let the suit proceed.
My lord,
let the suit proceed. The learned trial judge has recorded that they have complied with this.
My lord, that has not been complied. My lord, the court has, my lord, written in the so many terms, my lord, that this is not a willful default. Therefore, my lord, the court non-production by a cannot be expressive issued to be a ground on the state rule for invoking special provisions of the state order. From the submissions of it appears that the dependent file comprised which were available in government records. My lord, there was an earlier order, my lord, by virtue of which there was a direction that what document you have not filed. We have, my lord, specifically, my lord, this is the document which has filed that has no nexus to the no willful attempt on the part of to disregard the accordingly the court does not.
But it's a finding that he has complied with the order. He has filed the documents.
My lord, he has not filed the documents. Therefore, my lord, we have been directed to file applications, what documents he has not filed and what he was required to file. That application we have filed, that to court, my lord, found that whatever he has filed.
The order impugned the application and
This is an application by the wife, where the wife's maintenance application.
The Chatterjee, you are opposing.
No.
I am waiting to, my lord, see.
For wife, daughter's maintenance granted, wife's maintenance not granted on the ground that she was working erstwhile, ability to pay. Kindly takes the internal page. Page number.
Ability to earn.
Ability to earn.
What is your qualification? Who are you?
I am the wife.
That I understand. What is your qualification? What are you doing?
Qualification, my lord, as per my.
No, on the basis of what the learned trial judge has arrived at a finding that you have ability to earn.
In my application, I said that I used to take up job at rupees 10,000 at a call center, but due to my child, I had to leave.
What is your husband doing?
Husband is an IT employee earning about 1,26,000 as per his affidavit of assets. kindly takes the internal page.
Show me that she has ability to earn. Where is that?
That my lord, kindly takes page 1, 2, 3, 4, 5, 6, sixth page.
Sixth page
of the order.
It's a detailed order.
Under the above, my lord, his last paragraph, my lord, is got.
Under the facts and circumstances.
It appears the wife claimed to be engaged in a job which she quit in the month of November since there is no income of her own. In para 20 of the applicant, wife under section so and so, not mentioned the reason of resignation signifies that voluntarily left the job despite her ability to earn. It is not encourage the providing maintenance either party having source of income in spite of her ability to earn. According to instant case,
Where is your statement that why you have left the job? Where is that?
Kindly takes page 29. Paragraph 15 and 18. ঠিক আছে হ্যাঁ হ্যাঁ তাই তো বলেছি 17 15 and 17.
The issue that arises for that
27.
Yes.
Okay, when you suit for eviction, I am the defendant. So my 7-2 application has been rejected and my defense has been struck off on the basis that I have not deposited the admitted area rent along with the application under section 7.2.
Have you deposited the admitted areas of rent?
Lordship, there is no admitted areas of rent.
Show me your application under section
Lordship,
7.
kindly sees page 19. Yeah, Lordship, kindly sees paragraph 2, my lord. The defendant paid monthly rent to the plaintiff every month by month from inception of tenancy. Your petitioner wholeheartedly say and confirm that your defendant did not make any default of tenancy month to month till October 2016. Lordship, this is Lordship important. Then that it is not out of place to mention here further that after the taken over possession by the defendant herein as a tenant over that shop room, they used to pay month to month and keep record in his diary due to good relation among themselves, and the defendant was not pressing the landlady to issue rent receipt in favor of
Which paragraph you are placing?
Lordship, paragraph 3, my lord. Paragraph 2, Lordship, it says that till October 2016 he has received rent receipt. Paragraph
That
3.
is the statement after October 2016.
Lordship.
After October 2016. What
Yes,
is the
that is
statement?
what paragraph 3
Yes.
is that statement. It is not out of place to mention here further that after taken over possession by the defendant herein as a tenant over that shop room, they used to pay month to month and keep record in his diary due to good relationship among themselves. The defendant was not pressing the landlady to issue rent receipt in favor of your defendant. Surprisingly, 2 documents relating to rent receipt of June 1993 found in old file of landlady Srimati Anita Rai issued rent receipt of rupees 100 only. After scrutiny from where it is from, another rent receipt of landlady Srimati Anita Rai issued rent receipt of rupees 250 for the month of July 1995. Now, my lord, this is my statement. So it is envisaged that your defendant was, is not making any default of rent till date. After that, your petitioner was established himself as a old tenant paying the same through postal authorities on and from November 16 till date.
What is your statement? What is the fate of your remittance through the
There is,
postal
Lordship, that is my first argument, that apropos these, the Lordship, evidence ought to have been taken. There was an
What
application.
is your statement? What is your statement with regard to that?
My statement regard to
From November. That is why I asked you. October accepted. From November.
Lordship, from November onwards, I tendered the rent by money order.
You stopped at that. What happened after that? Received, accepted, returned.
No, it was refused.
Deliberately refused, wherever stated. So refusal, if that is refusal, what steps you have to take?
There is the steps have to be taken. Millard, it is not an admitted. Lordship, I'll rely on a judgment, Millard.
Yes.
Kindly takes.
I'm bound by my own judgment.
Lordship, kindly sees paragraph 3.
Yes.
In my opinion, learned civil judge was wrong in his view that any tender of payment by a tenant prior to service of notice of demand is irrelevant to the question whether he had committed.
Different thing. What is the provision of section 3(1)(a)?
Lordship, kindly, Lordship, 3(1) is different, my lord. Thereafter, the Lordship has
applied.
Lordship holds, my lord. Kindly sees, if a landlord without lawful excuse refuses to accept rent tendered by tenant, he cannot afterward treat the tenant as defaulter or serve a notice of demand.
Sir, our statute says otherwise. When it returns, your obligation is there under section 20 and 21.
Lordship, I admit, my lord. But, my lord, I said, I maintain my record in diary.
To that, I have said October 2016, no problem.
October 2016 is with rent
November,
receipt. Till October 2016, I've got rent receipt.
Yes.
Post October 16, there is a diary which I maintain.
Your own statement says you have not stated that. That after November, you have paid, you have said, how do you maintain diary? Your case is that you are remitting through postal authorities.
I have also said that thereafter I have made payment, I have tendered it through postal authorities.
Yes, what happened after that? You have not.
It has been refused.
That have you stated that it has been refused?
Lordship, it has not been stated, but I would have stated, Lordship, had evidence been taken.
All facts have not been disclosed in the application.
But my lord, evidence ought to be taken.
The stamp dispute which you are raising.
It's not a stamp dispute, Lordship. I have annexed the receipts.
You have not.
I have annexed the receipts, my lord. I've got the diary
from November 2016 receipts. I'm not talking about the previous. October 2016, I am accepting.
Lordship,
from 2016, your statement is that you have remitted through postal money order.
One of them, Lordship, will see. I have annexed some of them. Lordship, kindly sees page 23.
Yes.
This is December 2016.
What happened to this?
They have been refused, my lord.
So then, if they are refused, what is your obligation?
There is an obligation, but my lord,
to perform. So, and that is also not default. Come at 2 p.m.
I try to bring some more.
Lord, Mr. Kaur was arguing on the other side. Mr. Chatterjee was there. Lord, tomorrow is the date fixed.
31. Now I am on 27. Any indication is there?
Yes, there are some
Monthly. Some 2 p.m. are there.
And thereafter, monthly list will not, we were told that after 2 monthly list matters will be called.
Where? PM fixed matters, urgent matters are there. Let me see how. After this, Mr. Mukherjee, after I conclude up to 38.
Lordship, I tried to find out Lordship's judgment. Lordship, will it be Lordship's pleasure to keep it tomorrow, Lordship? I shall do some research, my Lord, only for that purpose.
All right.
Great.
Item number 1608.
Yes. Well, it is that matter, my lord, where
I prefer the opposite party.
the last occasions, the matter when was taken up, my lord, after considering the entire aspect, passed an order. I'll just place the order which is under challenge. With all respect, I must say, what is this? What type of order is it? No, order try page 31. Kindly come to page 31.
This
31. It's 31.
31.
31 or 32, my lord. It's like that. Operating portion at 32. Have you got it, my lord?
Yes.
Kindly see.
That is the impugned order.
That's the impugned order, which is under challenge.
Yes, impugned order, I am on the certified copy.
Just one. Yes. Upon perusal of petitions. Simple, my lord. At the top.
Yes.
Upon perusal of petition of respondent wife, along with medical documentations attached with this, as well as written objection filed by petitioner husband, and taking notes of submission of granted lawyer for both sides, I do find that though medical documentation in the form of a prescription as well as some investigation report have been attached, but no medical certificate purporting to be signed by a registered medical practitioner as evidence of sickness or infirmity of proposed witness as filed. However, considering the prescription of various medical certificates near future. And the second part is very interesting.
What is the suit for?
Divorce.
No, why this doctor's evidence is necessary?
That's why that is the big questions. And not only that, she the last person. The respondent wife. Last but one paragraph. The respondent wife shall file affidavit in chief after his evidence complete, everything. On behalf of her father, he will file evidence in chief. For the last 13 years, my client is suffering. Thrice, my lord passed an order, he should be disposed of immediately within 6 months. Till today it is pending. And today, father is a famous man, or imperious, I do not know. Anyway, so what are his daughter on behalf of the witness? Kindly take trouble to this. Well, this is very relevant. And my will suffice. I'm above law. I will not go to the court. Court will come to me.
No, what for? No, I could not understand. What for the doctor is to be examined? Why? What is the purpose?
It's not the doctor, it's the father of the defendant who is supposed to adduce evidence, but as DW2. Defendant is the wife. I appear for the wife, and the father is to be examined as the defendant's witness number 2.
Oh.
Well, he is 89 years old. That is why these medical.
That is not the factor. No, like this.
I'm not.
On the last evidence, I to increase by age. Well, I've already added some documents. So that appear is absolutely active persons. He doesn't want to go to the court. Nobody is above the law.
Where is the application?
That's page 39.
39.
Apart from various evidence, it was moving everywhere. After finishing, my lord, I'll show one thing.
Now, Mr. Banerjee, any objection filed to this?
Yes. But before that, I'm doing one more. Can we go to page 44? Can you come page 44?
44, yes.
Date nahi.
No,
Page 44, right?
Yes.
Date. No date. And next.
Sir, আমি যে date নিয়ে objection এ pointer নিয়ে
And in objection, we have taken the objection. আরেকটা document যেটা দেখাচ্ছি।
পরেরটা থেকে দেখুন এগুলো জুলাই 2024
Now, Mr. Banerjee, instead of going to this, what is the difficulty if the advocate commissioner, because is appointed for recording the evidence? What is the difficulty?
There is not.
I will expedite that. I will.
No, that attempt was passed out and that's entire court. 13 years it is pending. No, that is residence. Let the video, because I know the person for chief minister's
No, but you will be present at the time of that evidence. You will, yes, because advocate commissioner
he's moving everywhere. So, my lord, kindly come to the annexures, the pictures. That is why my lord written them.
No, Mr. Banerjee, show me. That is why I wanted to see the written objection. Have you stated that he is moving? Where is that written objection? Show me that.
50.
50. Show me that portion where you have stated that he is attending the other patients and other things.
And with the photograph I've given.
Page paragraph 12.
My lord, kindly take double to come paragraph 12. 7 paragraphs have stated there, my lord. And I've given a photograph. First, my lord, page 4 of this objection, running page 53. Paragraph 10. Paragraph 10 first, my lord. Have you got it, my lord? Paragraph 10. That the purported medical advice relied upon by the deponent of the instant application are misleading and do not support the contention urged in the application reply. The prescription used by Dr. Rajesh Jatput of CMRI is without any date and that issued by Dr. Indojit Sardar is dated 12 August 2024 and all the other report shows the date is July 2024. Till then, no update, nothing. He's then, subsequent to August 2024, the proposed witness of the defendant has attended several functions, worked out in his wheelchairs at many public functions, photograph to which I respectfully crave leave to refer to the time of the hearing of the application if necessary, and is carried out professional vocations as a doctor on regular basis. It is only one pretext or others, frivolous, concocted, and dubious as they are. The defendant is dealing hearing of the suit since 2024. The act of the defendant in implementing the jail practice provisions such.
72, 74.
Paragraph 12 to 14. Paragraph 12. With annex all the photographs.
72.
With reference to paragraph 12, the applicant I deny that the proposed witness of the defendant has restricted movement. I repeat and reiterate that the medical reports and the prescriptions annexed with this application are all dated such and such. Thereafter, the proposed witness had traveled at several functions and have attended the Chambers Hospital without using using wheelchair or whatsoever. I further state that it is a ploy and malafide conduct on the part of the defendant to record the deposition on commission just to avoid this learned court, as the defendant has no substantial case was answered.
Page 64.
Calcutta 64. 64 onwards. Calcutta 64.
64.
No, this is unfortunate. Horror করছিস কার সাথে শুনছেন পেজ 62
This is a photograph of which date?
All January onwards.
All January onwards. When I stated that, of course my lord is there. Everywhere is there.
Come to page 72.
72. Prestige.
He was in the Dharna Mancho. This was August 2024.
72. Well, let's see. Even without any stake. No, this is really very unfortunate.
74
Sir,
74 is 12th January.
74, my lord, 12 January.
12th January date is there.
74? Well, is 74? 7 photograph of Alex.
Subsequently, sir, 75 years book fair here.
And even he's out 75. What is happening in the court, my lord? What do you think that when he's out of the court?
Yes, what do you say? Are you disputing these facts?
The photographs are there. Photographs are there. I can't for one say that he's not traveling anywhere.
Then
the issue is, if I go
if
through
you
the
can
pleading-
travel, you can attend the hospitals. Why can't you attend the court?
Yes.
There is only one thing. There is only one issue. From the pleading, what has been pleaded is that the case has been dragged for years. Now,
No, but the fact remains they're disputing this.
yes, the medical records are there, but he may be able to walk. I'm not saying that he is not able to walk.
On one day, I will direct. On a particular day, we'll go, and on that day itself, the evidence.
And he'll go in with the chair.
Senior friend just now said that nobody listens. But even if your lordship passes an order, nobody
No, no,
listens.
no. That is a
senior
different.
friend said.
That is a different thing that he has made subject.
What I was proposing, instead, what
So I will direct Mr. Banerjee's client to cross-examine him on that particular day.
And he'll be provided the chair. He'll be provided the chair.
What the medical records would say that he has a problem in both his knees. Knees have to be operated. They have not been operated. That's a separate issue. But he may not be able to stand for a while.
So chair will be provided.
Yes, that is fine. What I was proposing is, if your lordship, if the
Please take
commissioner is there,
instructions. I'm keeping tomorrow. So chair will be provided. Whatever other facilities.
Yes.
That will be provided. But, and also take instruction, because this is the specific instructions and the photographs and other things. In the written objection, they have stated that you are attending.
In the
So
written
it's very
objection, they have
difficult
stated
because you are attending the clinics and other places.
the photographs are there. I can't dispute these
So
photographs.
then you are shying away from attending the court for giving evidence.
He's about 90 years old.
But you are attending. You are attending clinics. You are attending other functions at that age. Many,
But on that, I
many
haven't
of
done-
the legal profession persons, 90 years, you will be finding
my lord,
books there
My
appear.
senior friend is there. Even
I mean,
Not 90.
I've seen
You are not saying anything to.
বলবো এসব ছেলেপুলেরা যাতা করছে মানে I've seen this court division bench and
If he is attending the
kindly come to page 9
and keep it tomorrow.
Lordship will keep it
What
tomorrow.
facilities he
Yes.
required, please take instructions. I will.
Nobody's having the law. Nobody's having the court. Maybe it's the sound that court.
Yes.
Even I have legal arguments to make, but
That is the next date fixed.
next date,
No one has fixed.
Be stayed by this court.
Lordship will state the suit. That is
Right.
I feel it. Well, page 9 just one.
On the
just
next date, he will. Any date has been fixed for operation, knee operation.
no,
No,
that's
nothing.
not- I'll take instruction, whatever the instruction.
That tomorrow they can come with that. No, already position. That means there's something wrong.
Whatever the reality is, I'll inform your lordship then, and your lordship
Please
will
take
take a call.
instructions whether he is attending clinics,
Yes.
Kindly come to page 9.
where, in which places, in which clinics he is attending,
Yes.
and on the next day, what facility he wants. If he cannot stand, I will ask that some chair is to be provided. Mr. Banerjee, you cannot object to that.
I agree. But kindly come to page 9 just one.
Any other facilities, any wheelchair for going, in which floor is this courtroom, Mr. Banerjee?
My lord.
In which floor is the courtroom?
First floor, first floor, I'm told.
First floor lift is available.
Doesn't matter. He's using the stair. Kindly come to page 9.
Yes.
Page 9.
But I take instruction whether he
Take
can
instructions
take the
on that.
stairs.
Well, page 9 is very good. Page 9, para 5.
If it is,
না না বলতে বাবা এটা বলতে দিন না প্রত্যেক ক্লিনিকে যাচ্ছে ঘুরঘুরে যাচ্ছে top
The names of the clinics have also.
given the document,
Very difficult to say also.
I will have to take instruction. What I'm on is, if my instruction is he can't take the stairs,
then Lordship may keep 1 day for commission. Then on that day itself, for even for expeditious
Residence. I know what will happen.
expeditious disposal, Lordship knows order 26.
But if he is climbing stairs in other places and you are saying here he will not be able to.
No,
finish-
that I'm not saying. That I'm not saying. If he, I'll take instruction. If he can take the stairs, if he can stand for a while, I'll take all those
No,
instructions.
standing, be rest assured, he may not be able to stand at that age for a long time. I will provide direct the Lane Traja to provide for the chair and any other facility.
I understand. I'll take instruction.
Mr. Banerjee.
I love some influential persons, money man also, but
Mr.
law discriminates.
Mr. Banerjee, there may be also some difficulties because age is also a factor.
My lord, I can assure you, my lord, I could understood that well. The operation has been done. He cannot move elsewhere. He is moving everywhere, attending the chamber.
But if a patient suffers from knee problem, Mr. Banerjee, you know, it's
Conference
very
160.
difficult.
Huh?
Very difficult to move patients having knee problem. That is also there.
He can go so many hospitals in one day and attending on chamber. His mobility is still strong.
No, he's not traveling in so many hospitals in one day. He's going to be enlisted as a doctor in many hospitals.
My lord, just come to one
everywhere.
For that, I am asking you to take instruction.
I'll take it.
My lord, kindly once just.
Because
Patient
those are
of
statements on
osteoarthritis.
affidavit. Those are statements on affidavit.
Yes.
I can call upon you to deny that by way of an affidavit. So prior to that, I've not asked you to do so. I've only asked you to take instruction.
My lord, one second. Kindly come to page 164. Need to doubt to Victor. 164.
164.
Yes.
That's why we say no residence. Any neutrality.
His arms is long enough. Have you got it, my lord?
Those are- Don't go into those.
I'm very much scared.
Let us not go into those
Anyway.
because it's only the issue.
Yes.
He was
This is my
a
lord.
witness. So the court is to be considered only with regard to two things: whether he can attend the court or is in a position physically to attend the court. That is only to be considered.
That means you another we have satisfied losses, my lord. That's why my lord entertained.
Rule 4, even for expeditious disposal, commission can be ordered. Lordship knows, my lord. Rule 4.
Yes.
May I leave my
Yes. Call the next matter.
Item number 143.
Yes, Mr. Rai.
my lord, the application under section order 11 has been rejected. I am the preemptee. I am the preemptee.
You are the preemptee.
In the
Order 7,
application,
Rule 11. What is the ground in
yes,
order
my lord,
7?
kindly consider and turn to page 9.
Page 9.
Yes. May I read out for your lordship, my lord? From the top.
Yes.
নালিশি 1 নম্বর দাগের মালিক উক্ত তন্ময় দাস অধীন দরখাস্ত নালিশি দাগের বর্গাদার হওয়া সত্ত্বেও তাহাকে কিছুমাত্র জানিতে না দিয়া গোপনে ক্রেতা প্রতিপক্ষকে নিম্ন তফসিল বর্ণিত 491 দাগে তার অংশ ভূমির মধ্যে অবিভক্ত নিম্ন তফসিল ভূমি বাংলা 1430 সালে 5ই জ্যৈষ্ঠ 21/6/2023 তারিখে সম্পাদিত রেজিস্ট্রি বিক্রয় কবলা বলে বিক্রয় করিয়াছে। So this is the now I can turn to the deed itself. Because they rely upon this deed. Paragraph page 6. Last
So is there any provision for giving notice to the Borgadar?
that is immaterial.
Yes.
Middle portion.
Yes.
This deed is there one to preempt. 2012 and 2016. Well, got it.
Yes. Yes.
Then where is the and the co-sharer? This is a deed which is subject matter preemption is 2023. In the said deed, it was mentioned already that he have purchased property from B 2012 and 2016. These documents are relied upon. If that be so, my lord, the transfer is effected in favor of co-sharer. Then how could the preemption will apply? I could understand that I am bringing some other documents. These documents are relied upon. This is the subject matter preemption. This deed.
But Mr. Rai, that is the matter of trial.
I could have understood matter of trial. They are relied upon. My lord, I am only basis.
What is the stage of the suit?
Initial injunction. But can you consider once, if you want to rely upon a document, it is your document. You have relied upon. If they are disputing this document, then their case also goes. They cannot take both advantage, appropriate information on one document. They have filed this application on the basis of this document, that this 2023 deed, which is transferred in favor of a stranger.
Dr. Juma Sutrodhar.
Yes. This is a petition before your lordship.
That is the opposite party. That is the opposite party.
Yes.
PMT.
PMT. And Tanmay is the admitted vendor. He also admitted in their application.
But in the preemption application, that has not been stated.
Nothing stated. Then I can explain your lordship under orders are relevant. Now the honorable says the documents which are relied upon, I can explain those documents. I need not to go for any trial. It is because it is their admitted documents. And I am armed with the judgment where your lordship was there. You know, but is there without co-sharer, in absence of co-sharer, there is no preemption.
No, in the absence of co-sharer, they are.
And it is transferred to the co-sharer then also, unless I
yes, to a person other than a
co-sharer. This other than co-sharer, so I have a co-sharer. This is admitted document.
This is the deed which is sought to be preempted.
Preempted. So they cannot resile from this document.
So initially a portion was transferred. Thereafter it's the balance portion. Entirety.
Not this entirety, some portion again transfer. Yes, to the fact, now I can consider it that way.
There is substance in the argument of Mr. Rai.
Another application after 5 days within
Next.
Item number 337.
My lord, this is an application for expeditious disposal of the title suit.
Let's I appear on behalf of the opposite party, my lord, number one. It is my suit. My lord, we had written to them way back on 5th February, informing them that we are appearing on behalf of, my lord, the opposite party number one. They refused to accept the letter. Then, my lord, an
This
email
has not
was
even
sent.
been accepted,
Then an
admitted
email
before
was
this
sent.
honorable court.
An email was sent. My lord, to that also there is no reply. I don't know whether this has been upgraded or not. My lord, at least a notice should have been given to us. And at
No,
least
this has
a copy
not
should
been
have
admitted. Unless it is admitted, how can I serve copies?
But madam, when they are writing letters to you, you are not accepting that. You have mentioned for upgradation, the minimum that was expected from you is to notify them.
My lord, this
When
is
they are
an
writing letters asking you to give copies, why are you refusing that letter?
My lord, I have mentioned this matter. That's why if it is admitted, then with the direction of this honorable court, I would have served them a copy.
All right.
But this is an expeditious
All
disposal,
right.
my lord.
Yes, yes. When this matter is taken up for hearing, the learned advocate for the opposite party appears and prays for a direction upon the appears and submits that the opposite party wrote letters to the learned advocate for the petitioner, but she refused to. Praying for serving a copy of the civil division application upon him, but such letter was refused to be refused by the learned advocate for the petitioner. Petitioner is directed to serve a copy of this application upon the opposite. And please serve.
He fixes it any day this month.
Yes, yes, please serve thereafter. Yes, next.
Item number 374.
None appears for the
Item number 701.
I'm the petitioner.
Yes.
This is the affidavit of service pursuant to the earlier directs by the coordinate.
Where is the other side? Have
Other
you
side has been
informed?
informed even at the time of mentioning, my lord.
Yes.
Original notice has been handed over at the time of mentioning. This is the copy. Refused.
Yes.
Well, it is the matter wherein the learned executive court has modified or corrected the degree in execution. Actually, at the time of hearing of Miss case for police help, it was detected that the description of the degree is wrong, and the degree holder immediately filed one application for correction of the degree before the executing court in the said Miss case for police help, and the executing court has corrected it by the impugned order. My challenge is that in the revisional application is that the executing court is powerless to modify or correct any decree in execution. It is the court of original jurisdiction who passed the degree only can modify or correct the degree which is under the execution. If you also kindly turn to the impugned order, my lord. One application filed for section 152 for correction of the degree and which has been corrected by the executing court. And such application is page 22 of my application, of my revisional application.
It's too technical because the court is same. It's the decree court can also exercise the power 152.
I have one humble submission, my lord. The forum is
Merely
different.
because it was on an application.
The forum is different. When I
The effect is that the decree has been corrected.
why I am submitting, my lord, kindly appreciate, my lord. The executing court doesn't have the original record with it.
Executing court is also the trial court. The trial court's record, the decree is corrected. Records must have been produced before the executing court. Otherwise, it could not have been corrected. Show me your statement that you have said that the records were not produced because the decree has been corrected.
The
It's
certified
too
copy of
technical. What's the decree for?
decree for eviction. Decree for eviction, I have lost in all courts in appeal. Now decree put into execution, and at the time of police held, the said application was filed. My humble submission is that since the jurisdiction is different and the forum is different, in case, kindly appreciate, my lord, in case the
Show me which court passed the decree. Show me which court passed the decree.
the first court of civil judge junior division at Sirampur.
Yes, that court corrected the decree.
But in separate jurisdiction, my lord. In separate jurisdiction, my lord. The executing court, if started correcting the decree for the purpose of execution, then in case of section 47
This application under Article 227 of the Constitution of India is at the instance of the judgment debtor and is directed against an order being number 102 dated June 18, 2024, passed by the Learned Civil Judge Junior Division First Court at Sirampur in title execution case number 10 of 2013. Full stop. At what stage, Mr. Banerjee?
Is in the interlocutory stage still, Lordship.
No, trial commenced.
No, interlocutory stage.
Trial.
No, interlocutory stage. If your Lordship kindly turns to my
What is the
page,
application?
page 23, Lordship. Unmarked page 23.
Unmarked means?
He has 23, Lordship.
You said unmarked page 23
I mean,
means?
paginate, probably in that is, Lordship has got the paginate.
I've been benefited with the pagination.
Lordship. Then 23 is the, if your Lordship kindly see at page 24, Arjir Sangshodhon Jotha. After 19, Lordship, we will insert this. বর্তমান মোকদ্দমা চলাকালীন মূল বিবাদীগণ অন্য
the plaint?
Lordship, plaint is at page 12. If your Lordship kindly takes up that para, which will be relevant, para 19. And with regard to para 15, Lordship, we have page 17, para 15. I stated that I am continuing my agricultural activity there. Now, if your Lordship kindly turn to page 27.
There is substance in
Yes, my lord, I'm the petitioner. My lord, last direction was to exhibit the plaint copy. Please have a look, sir, my lord, the page number 3.5 and 6.
Yes, what is this application for?
My lord, for local inspection. Actually, opposite party violated the injunction during the injunction period. So there is some deviation the status quo. So proper adjudication, the scenario should be learned before the landed trial court. That's why I'm filing the petition. My humble prayer only for to allow this local inspection, my petitions.
No, where is the plaint?
Plaint
I've
is
asked
annexed.
you to produce the plaint.
Plaint is annexed, my lord.
Show me the plaint. Which page plaint has been annexed?
No, it's not there.
My lord, page number 32.
32.
After the judge order sheet of Planet Civil Judge Junior Division.
So that is the application under order 26 rule 9. That is annexed, you are producing that.
My lord.
Plaint is you are not producing.
My lord, just
Even today the petition. Please produce the plaint.
Item 1301, I'm for the plaintiff's petitioners, my lord. This is my affidavit of service. Since there was a
Item
caveat.
number?
1301.
Yes.
Yes, my lord. I'm for the plaintiff petitioners, my lord. This is my affidavit of service. Since there was a caveat in this matter, I have served copies of the.
I am appearing, my lord. The copy served lacks some pages. My lord, may I come back tomorrow? Let it be served.
Lord, I've served complete set of
My lord,
the.
pages are missing.
Which
Few
pages?
That I will hand to. And mentioning notice was not served. May it be taken up day after tomorrow. In the meantime, if he serves, the matter may be disposed.
For mentioning, you have not served any notice.
No, my lord. For mentioning, I did not. Because there was a caveat in the matter, my lord. I did not expect
is
it
in the
to be
monthly
upgraded
list.
so soon, my lord. That is why I'll serve it in the course of the day, my lord. I'll serve.
Did not expect to be upgraded so soon.
My lord, actually.
So your urgency was
No, no, no,
not that.
there is urgency, my lord. I'll serve it in the course of the day only, my lord. It is.
When did you expect this matter to be upgraded?
My lord,
What was your expectation?
My lord, I mentioned it on Wednesday, my lord. It is my lacuna, my lord. I tender my apology, my lord. I'll serve it in the course of the day.
Dates are fixed, I think, in the last week. Fixed all the dates for all the matters.
I'll serve
You
it.
chose not to verify, not to.
No, my lord, I had served copies of the revisional
How do
application.
they know that you will be upgrading?
My lord, it is my mistake, my lord. Kindly, my lord, keeps it anytime. I'll serve in the course of the day.
Again mentioned thereafter. The learned advocate for the opposite party submits.
Golden hands for the
You have forgotten to bring the brief. Mr. Das, no. This matter was mentioned citing. Mr. Das, if you are not ready, you are not ready. Then move the matter. If you are ready, you move the matter. This matter was. Yes.
Matter was appeared, my lord, submitted the notice for upgradation, and my lord, on Friday itself, my lord, we have given application.
Who is the learned advocate?
Mr. Nilakanti Ghosh, my lord.
Where is he? Yes, Mr. Mukherjee. Yes, short passover. Passover. Yes.
Item number 1564.
This matter was mentioned citing.
Daily list. Item number 277.
Yes.
My lord, I am for the opposite party. It was mentioned at my instance, and before mentioning and after mentioning, I have notified the petitioner. This civil revision arises out of an execution proceedings.
Who is appearing? Mr. Nayan Banerjee.
Yes, my lord.
For the petitioner, you are for the opposite.
I am for the opposite party, mentioned at my instance, and before mentioning and after mentioning, I have notified the petitioner. This citing the pendency of this civil revision application, the adjournments are being taken at the executing court. My 18 crores is pending for the last 40 years. My land was acquired way back in 1979.
Inform Mr. Banerjee, ask him to come. Pass over.
Item number 203.
Item number 77 आगे डाल लें तो You are appearing. You are opposing. Yes.
My lord, depends the petition for lord. The suit for my lord, eviction, not trespass.
Suit for
eviction of a trespasser on the ground of 2G.
Yes.
I filed an application for water connection. And that was, and along with an application for under Order 13 Rule 7. On this premises, my lord, my application has been rejected.
Application for water connection.
Yes, restoration of water. Now I can turn to my application once. Page 46.
Suit filed on the ground of trespasser. Trespasser is entitled to supply of water, Mr. Rai.
I am a tenant, my lord. That is why, my lord, can I turn to the plaint itself.
Order 13 Rule 7 was an inspection.
Yes.
Yes, Mr. Mukherjee.
My lord, can I, one thing, my lord. So about the plaint, what is the ground? That 5 years from the enactment, so I became a trespasser. Now, in view of the judges, my lord, probably, my lord.
Mr. Roy is not arguing the matter on merits, my lord, in respect.
No, that is a finding. That is the finding of the court below while rejecting my application. Last, or the plaintiff filed the suit for eviction of trespasser on the premises. J. Fernandez was recorded 10 in the suit plat, died in the year 1998. And after his death, wife
came into force in 2001.
2001, 10th July.
July
2001, 10th July.
Where is your application under Order 13 Rule 7?
Yes, that your lordship will find at page 51. Point for inspection, page 52.
And where is your 151 application?
That your lordship will find at page 46.
Mr. Mukherjee, there are two ways. One is for, if the water connection is restored, is one thing. I can direct that. I can direct the expeditious hearing of the suit. Or if you dispute that no, he's getting water, then local inspection and other things are to be done.
But my learned senior friend has placed the matter in such an innocuous way, but it is not that. It has a checkered history. Earlier, 151 application coupled with local inspection, all has been rejected on merit, no challenge. Thereafter, another application filed, he is not residing. On behalf of a power of attorney, some third party came and filed this application.
Where is that earlier?
Kindly takes up.
But that is not the ground here.
Yes, kindly see, this application once allowed. I challenge that, filed a revisional application before this honorable court. The coordinate bench, noticing all of that fact, ultimately set aside that order of allowing local inspection and remand the matter back. That's why I have shown. Now, kindly takes up the coordinate bench
35.
order. That will clear everything. Page 37, it starts. Has you got it? Page 37. The entire conduct is being canvassed. Kindly go through this order once. Thereafter, I shall make my submission. So in 2017, his prayer for restoration of water supply is being rejected, holding that he is not residing in the premises.
Yes. Yes.
The remand order, my lord, has noticed that what has been directed to be done by this honorable court, that the learned judge, 5th bench, City Civil Court, Calcutta, in connection with title suit number such and such, is directed to hear out the petition dated 29th January 2018.
What is that?
Kindly see, what my learned senior friend has just now shown before your lordship. What is the petition that is of 2024?
No, so this was the remand. What is 29th of January 2020?
That is his earlier application.
Where is that?
That has not been annexed, my lord. I could not able
So
to
pursuant to this remand, this order was passed.
No, subject to question provided by learned friend is not. That was filed by the power of attorney holder.
Yes.
Yes, that is recorded. Page 41.
Which, according to the this honorable court, coordinate bench says a sub-delegation of power cannot be
Yes,
done.
that is why the person, the defendant himself come forward and file this application.
Whether that liberty was granted by this honorable court, subject to correction. My learned senior friend is suggesting that is why he cured the mistake. Whether that was the direction. Direction was that faulty application needs to be here out. How many times this
Page 39
defendant will come? He initially came as being the defendant number 2 and power of attorney holder of defendant number 1 and 3.
No, show me, Mr. Mukherjee, that this was the reasons for rejecting. Show me what is the reasons for rejecting. Show me that since the earlier application was rejected, for such reason this application is barred by res judicata and
that
it was
has been directed by the your lordship knows.
Show me the reasoning.
I'm coming. Today, I know that is not there. Today, if being a revisional court, your lordship is with me with regard to the conclusion part, your lordship can always supply the reason. Because this honorable court in the same matter has already held that times and again, since from 2017, this person is asking for a water connection who is not residing over there. His Aadhaar card, he has been produced before the trial court. Kindly see where he is residing. This has been produced before the trial court. It's a courts of record below. By the direction of the honorable court, learned trial judge, he has produced this Aadhaar card. Admittedly, he is not residing over there.
Who is admitted? Who has admitted?
And a person, my lord, who is residing over there since from 2017 without water supply. In 2025, when the matter is posted at for the examination, for the cross-examination of the defendant witness to delay the suit, every endeavor is.
Mr. Mukherjee, where is the earlier order dated 14th of September 2017?
Yes.
Page 39, you will logically turn to page 39. It starts from page 37. Page 42.
14th of September 2017.
Application order.
Page 42.
Yes, page 40. 14th September 2017.
What is the reason for rejecting? Kindly consider. Therefore, the reason is, my lord, will find what is the reason? Bismillah Khan.
So this was challenged. No,
This was not challenged as the part of it.
your order. So this was not challenged.
Challenge.
Where
Subsequent
is
page.
the order dated 22nd of February 2018?
22nd February 2018 is at page Milord 33, which was challenged by my client Milord before the revision report.
33.
Yes.
Yes.
It starts from 33, relevant portion is 34.
This order has been set aside.
Yes.
As your
So
lordship,
this
now-
was set aside by
now I
the
will clear the missing link Milord. Now this has been set aside and order has been remanded back matter. Kindly now takes up page 44. Page 44 is after order of remand by this honorable court. Kindly read Milord. Again, not appearance, show cause, no show cause file, dismiss. Even no recalling to this. In 2024, another Milord petition for local inspection, since the matter has now been opened up to the evidence stage.
What is the stage of the suit?
Milord, the cross-examination of the defendant's witness. Times and again, Milord, they are absent.
Now, my lord, may I-
Now, Mr. Rai only.
was filed and what is the occasion?
Mr. Rai, since when you are without water
Yes.
supply?
Yes, can turn to page 51.
Yes. 51 is the present application.
Yes, yes.
Yes.
এক মিনিট দাঁড়া তুই আমাকে আর বলি না। Can you turn to paragraph 4?
Paragraph
4, page 47. 47. 151 application.
No, I want to know the time since
Yes,
when you are
yes,
without
yes.
active,
That you lost
water
to find.
connection.
Can you turn to paragraph 7? That on such and such an urgent petition filed by the honorable defendants on the 1st of
2024, 16th of July 2024.
Morning defendant was surprised to find that there was no flow of water through the pipe inside this flat and on
So 16th of July 2024 morning, you are without water connection. Now, what is the first application which you have filed? At a kagos din to? Sada kagos din.
আগে application 29/1/2018 subject to action.
29/1/2018. What have you done?
After that it was restored. It was restored.
No. Please kindly come to page 51.
Yes.
Page 51 in this application, you have said that water supply has been connected since disconnected since 16th of July 2024. So thereafter, when did you file application?
Immediately, my lord, at the top, page 46 at the top. 15/7.
What are the other applications for? The previous applications?
31/7/2024, the application was filed.
31/7,
2024.
this application,
Yes.
application filed. And what was the cause of action for filing the other applications? And where is the case made out that subsequently water supply was restored?
Yes. সেটা যশোরের কথা বলেছে কিনা
ডিসকানেকশন একটা হয়েছে যখন থেকে তখন থেকে আসছে তার আগে দেখার কজ অফ অ্যাকশন তাহলে আমরা রাখতে পারি
না না মানে ইয়ে করে কোশ্চেন করেছিল না কবে থেকে বন্ধ করেছে
Your Lordship is asking, Lord, the initial date of disconnection as alleged is 22nd of June 2017.
Yes, the application filed.
That is at page 33.
22nd of June.
June 2017 at 8 p.m. As per him, the supply of water connection has been completely disconnected, which was dealt with by the learned trial judge, my lord, at page 33 by the order number 34. Dated
Connected.
Yes.
Thereafter, application filed.
Thereafter, application
filed.
When?
The application under order 39.
29/1/2018.
18.
Yes.
With that.
Thereafter, these orders were passed, rejected, and remanded. Now, Mr. Rai, so
can you turn to page 56?
56, yes.
Paragraph 3. Or we paragraph ta kotha 151 application 46. So this is the denial of tenancy right after that paragraph 4. Your lordship fine.
No, what is this?
The objection file.
Objection.
Yes, that is why how they have dealt with my amendment.
No. Please show me your case that initially 2017 supply was disconnected. Thereafter, you file an application for restoration. You could not obtain any order, positive order in your favor from the learned trial judge. According to you, supply was restored. Show me that statement.
That statement, if you logically consider, ওটা দেখতো প্যারাগ্রাফ 8 ডিল করলো কি করে Yes, my lord, can you turn to the my lord is looking regarding my authenticity of my statement made in paragraph 8 of my application. That is a categorically this is the authenticity of my statement that on and from 16/7/2024 the correction was stopped. Apropos to this, my lord, can you consider the objection? Where is the denial?
Yes. Yes.
And turn to paragraph 8. Paragraph 7. Okay. I turn to page 65, paragraph 6.
No, you are placing this written objection.
Yes, 2 objections are there.
All right, page 65.
Yes.
Yes. Yes.
Paragraph 6. There is reference to paragraph number 34567.
Which
paragraph 6, page 65, paragraph 6.
Yes.
Which deals with my paragraph 8 in my application.
Paragraph 8 is being dealt with in paragraph 7.
Yes, after that, paragraph 7. After that is why, my lord, these two. Plaintiff denies that there was no flow of water through taps inside the flat of the defendants, and on calling the plumber, the plaintiff denies it was noted that the water supply
statement he has denied.
After
you have said on such and such, that has been denied.
Paragraph 4 is my positive statement.
Paragraph
4 of my written objection. That since from 2015, no one is residing over there. Page 65.
Mr. Rai, how many witnesses you have? I'm expediting that.
No,
You are since July. July is coming. Almost 1 year.
Therefore, my lord, a
So-
parcel is without a water.
Yes, yes.
No, my lord.
So I'm how many witnesses? What is the next date fix? I will expedite that.
Since the water line was not cutted, my lord, kindly consider the objection once.
Yes.
Page 66.
Yes.
Supply line to premises in question has been cut off and disturbed by the plaintiff from the main water line as wrongly alleged at all. Since the water line was not cutted and hence the question of raising protest to restore the supply did not arise at all. And the plaintiff denies all the allegations made no threat to any manner whatsoever. So how it is their case they have not stopped the water connection?
Yes.
If that be so, my lord, so this is the specific amendment made. And the court proceedings are being a trespasser have not entitled to get any electrical water connection.
Conduct shows so.
What are the conduct, even biologically considered? The suit has been filed trespass on the face of the record and satisfy your lordship.
This matter reminds me of a first appeal.
Well, so far, can you record that a person who filed a suit for
That was-
trespass is not entitled
You are
to
on
any.
water connection. That was for lift.
Lift is something else, my lord.
That was for lift. First appeal. Immediately this reminds me of that.
Well, can you consider?
I'm expediting the suit, Mr. Rai.
Then, my lord, if you logically consider, what is the reason for rejecting my application?
I'm supplying the reasons.
My lord, if that be so, my lord, if that, then why is the denial on the fact? Yes, there is no electric.
Mr. Rai, show me that when, according to you, 2017 initially water supply was disconnected. Show me when it was restored.
Where is the denial it was not restored?
I'm asking you, show me your positive statement.
My positive statement
They
is
say,
on
according
24.
to you, your statement is a 16 July 2024. It was,
Disconnected.
yes. They have denied that. That does not mean
They are not denied. That is a statement. That is your logically considered once. With reference to paragraph 8 of the said application, the plaintiff denies on and such no flow of water through taps inside the flat. The defendants and calling the plumber and the plaintiff denies it was noted the water supply line to the question has been cut off and disturbed by the plaintiff from the main water line as wrongly alleged or at all. Since the water line was not cutted and hence the question of raising protest to the rest of the supply did not or does not arise at all. So where is I put this question to myself? Where is the amendment denial that there is no supply of water? On the contrary, they have admitted yes, there is a supply of water and plaintiff did not stop the water supply. So if that be the statement made while in my amendment, there is no occasion. The court I could have understood that there is some denial on that fact. But can you consider what is the denial?
how are you managing to stay there without water, Mr. Rai?
Buddy,
For 1 year. For 1 year.
that means a person having Malat Kali consider.
1 year.
So therefore, Malat, if
Yes, what is the next date fix? How many witnesses you have? I will direct day-to-day conducting of the evidence. How many witnesses you have?
then Malat, filing of an application for restoration of water will expedite the suit.
No. I'm asking you. No. So that you know, if you succeed, I will direct you to file an application.
On the basis whether I have a trespass or not.
Try conduct, because initially I was in your favor. I have not asked you. I called upon Mr. Mukherjee.
Yes.
Conduct is
So Malat, the getting SSS service, the conduct.
yes. Has to be.
Then Malat, suit has been filed. On the face of the record, I am satisfying your lordship that is a tenant. Whether the SSS supply can be cut down in such a manner that yes, you did not apply for the same or file an application. What is the premises for rejecting my application? Then a power of attorney holder has filed that application. He cannot subdelegate. 2018, 19.
So in 2018, Mr. Rai, supply was there.
Yeah.
You are deciding that.
That is why.
Deciding that, but you did not file that.
After that,
Immediately,
the supply was restored.
Why you did not move the earlier application after remand?
It was restored. Water supply restored. That is a specific statement made.
Show me your application. Where have you stated? I want to see that.
That is what, my lord, I categorically come forward and said this is the date from which I am not getting the water supply. My lord is considering whether there is restoration or not. This is a positive statement. Why is the denial of that fact? No, you are not getting the water supply from there because previously there is no question of granting water supply. 2017, you are not having no water supply. On the contrary, here the specific statement made by the plaintiff that I have not stopped the what you are getting. So if that be so, my lord, kindly consider whether the water supply was there or not. From their own admission, it will appear that there is water supply. And whether, my lord, the absence of such protection, no relief can be granted.
What protection?
Yes, it appears from the register disputed that the order impugned.
Yes.
The plaintiff has filed the suit for eviction of trespassers on the premises. He has found a recorded tenant in the suit plat who died in the year 1998. And after his death, his wife being such and such, thereafter the defendant is occupying the suit plat under the tenancy of illegally despite repeated requests. It appears from the statement it is not disputed that the defendants are not admitted as tenant. It is the suit property, therefore privacy. The relationship landlord tenant does not exist.
So it was rejected on the ground that you are a trespasser.
Yes, on the ground that the original tenant died in the year 1998.
I never lied.
This is
I'm not joining an issue. With regard,
then, my lord, if this is the issue has been decided, then what is what remains in the trial?
that is the question. Issue is whether or not trespasser is 45
Because the court proceeded with that I am a trespasser. 5 years.
Anything more, Mr. Rai?
No.
This application under Article 227 আগে থেকে ডাকবেন তো, পিছন থেকে সামনে।
These two
160, yes.
matters are matters for expeditious disposal.
Yes, yes, expeditious hearing.
Yes. Now, my lord,
That order is there. Why do you want all matters this
I tell
direction?
your lordship, it was filed before. I agree, but here, my lord, in respect of
So hearing of the appeal was fixed on 24th of January.
yes,
What is the next date fixed?
next date fixed on 3rd July is the next date. My lord, it is pending for 17 years. 17 years. I have the judgment of your lordship. I bought this.
Produce that before the learned trial judge.
But pass this order, my lord. 17 years, my lord. Two
This
matters.
this application under Article
as well as damages, but they filed two appeal. Well, the same matter is the same date. Same.
What is the next matter?
Next matter, well, I tell your lordship.
What is the item number?
161. 161. Well, same.
61, same order.
One
Yes.
is against.
Call the next matter.
70. Well, next date is 14 July. I have made up.
14th of July in the next matter. Next matter টা তো না, এটা যেটা 3rd July.
My application for addition of party has been rejected. Suit filed by one Renuka. I am the heirs of Renuka. She died. Some of the heirs came forward and filed an application for substitution. Allowed. When we came to know, my lord, we filed an application for substitution. One by one.
I could not follow.
Initially, suit was filed by Renuka. Was the plaintiff. One Renuka.
Was filed by one Renuka.
Renuka.
Yes.
Suit disagreed. Appeal filed.
Suit disagreed.
Yes.
Yes.
Renuka died. Some of the legal heirs came and filed an application for substitution in place of Renuka. Allowed. We are the other heirs. We filed an application 151 for adding because we are the left out heirs.
Is there any dispute with regard to the?
Yes. That is why.
That is to be
25. I'll come. That application has been rejected. If a logically consider why
Which application has been rejected?
my application for additional party has been rejected on the ground. My lord, can last page of the order impute.
Yes.
Yes, of Renuka. My lord got it. Left out by the appellant by showing the certificate issued from municipal authority and Gram Panchayat. In my view, those documents left doubt with regard to the authenticity unless it is proved by authority concerned who have issued.
You have produced these certificates.
Then, my lord, what are the recourse to be followed, my lord? Judgment of this is the squarely it was held by the Honorable Apex Court that there is no other, you have to send down the records to the trial court and ask for the report whether they were actually yes or these or not. If your lordship can turn to the relevant portion, that is your lordship find page paragraph 13, 14. My lord, can you tell? And 17. My lord, can you turn to paragraph 17?
The appellate court can also decide that.
There is a provision of so two options. Either appellate court himself will come forward.
Yes.
Or
to be adjudicated.
Adjudicated.
So appellate court also can take evidence.
Yes, that is why there are two records. That is why I place this Supreme Court on the ground. Either you send the record, take a report, or appellate court can invite the producer's judgment.
By the order impugned, the application filed.
And there is confusion regarding the base date. Actually, it is 3rd July only, my lord. Actually, two suits are pending. That is also with regard to
3rd of July.
Yes, my lord.
3rd of July abar kore din, 14th of July. Yes, call the next matter.
Item number 243.
Yes.
My application, my lord. I am aggrieved by my rejection, the rejection by the learned court below of my application under Order 8, Rule 5.2. My lord, in a nutshell, I had filed a suit for specific performance of
Order 8, Rule 5.2.
Yes, lordship. Not appealable, lordship. I have.
No. What have you paid for?
Yes, lordship, kindly sees very briefly my plaint. My plaint case is that I was a developer in respect of, I was a prospective purchaser in respect of a premises that was being developed by one of the defendants, with the landowners being the other defendants implicated in the suit. I have paid up the entire consideration for purchase of the suit premises. A deed of conveyance was drawn up, executed, but could not be registered. Now, my lord, very conveniently, the landowners choose not to appear in the suit at all. The only appearance that was put in was by the confirming party developer, who has filed a written statement. I have annexed that written statement, my lord. And in a nutshell, the defendant number 3's case is that this defendant has nothing to do so far as the execution and registration of the conveyance is concerned. May I first, my lord, take my lord through the plaint case in brief?
Yes, according to you, if the court cannot direct you to prove that fact.
No, my lord, that is not the case I am running. My lord, kindly comes to the...
Precisely what has been said in Order 8, Rule 5.2.
Yes, the court may in its discretion...
Yes, the court has
definitely
exercised discretion.
Now, my lord, may I only place the...
Are you shying away from proving that fact?
I am not, my lord. My only case is this, my lord, bears with me for a moment. And I have a judgment to that effect, but first I will try to satisfy my lord before placing the judgment. In a suit for specific performance, the primary thing that I have to show before the trial court is my readiness.
Show me the judgment. Show me the judgment.
May I please place? This is my lord. Take to hand up, please.
Yes.
This is, my lord, Balraj Taneja versus Sunil Madan.
Which paragraph you are relying
Yes.
upon?
Straight away, my lord, comes to paragraph 7. Here, my lord, first, the Honorable Court sets out the various recourses available to a trial court if the defendant fails to file a pleading. My lord comes to paragraph 9 and 10. Also, my lord, on the CPC itself, paragraphs 11 and 12. And my lord, on this basis, may I bring my lord's kind attention to paragraph 29.
Yes.
My lord, here exactly what is falling from my lord is reiterated by the Honorable Court, that even when the defendant fails to file a pleading, or rather, especially when the defendant fails to file a pleading, the court adopts a more cautious approach. Now, my lord, my most respectful submission, paragraph 30. This is also, my lord, rendered in a context of a suit for specific performance. May I place, my lord, paragraph 30?
Yes, yes.
Applying these tests to the instant case, it will be noticed that in a suit for specific performance, it is mandatorily required by Section 16 of the Specific Relief Act to plead readiness and willingness of the plaintiff to perform his part of the contract. The court, before acting under Order 8, Rule 10, has to scrutinize the facts set out in the plaint to find out whether all requirements, especially those indicated in Section 16 of the Specific Relief Act, have been complied with or not. Readiness and willingness of the plaintiff to perform his part of the contract is a condition precedent to the passing of a decree for specific performance. My lord, in context of this, my lord, my plaint case shows I have paid the entire consideration and I was put in possession. A deed of conveyance was executed and only not registered due to the reluctance of the landowners. This is the specific plaint pleading, my lord. And the confirming party developer, in his written statement, does not deny any of these facts. He relegates himself only to this, my lord, that it is the execution and registration is not something that is cast upon him. If my lord so pleases, I shall
Show me where it has been held that the court cannot, in exercise of jurisdiction, ask the plaintiff to prove that part.
My lord,
Show me where it has been held.
I cannot, with utmost respect, my lord, that is not a proposition that I can argue.
Then
I can only, my lord, endeavor to satisfy my lord that the plaint
this
case
judgment
itself,
is against you, madam.
my lord, in a context of specific
Against you.
Yes, yes. Finally, it goes on to decide. But in this
Yes.
case, my lord, readiness and willingness was not.
How the judgment is to be passed, what are to be stated,
yes.
everything.
But my lord, it is my most respectful submission. When readiness and there is nothing left for me to perform.
Prove that suit will be, I'm expediting.
My lord will expedite the suit, and my lord will record my submissions to this.
This application under Article 220
My lord, I am for the opposite party.
I appear for the petitioner, my lord.
Yes, Mr. Banerjee, why are you not appearing?
Lord, the
They
matter
have
was-
given you a notice
matter
prior
was-
to mentioning, after mentioning.
the matter was
Neither you nor your junior is present.
matter was going on in court, my lord. Both of us are it's going on, my lord.
Someone should have been present here.
Sorry.
They are alleging that, yes,
I didn't allege anything.
No, no,
yes, you made that allegation.
the allegation,
They are online, we
I'll
can,
take care of the allegation after we go outside court, my lord.
yes.
No, I am for the petitioner. I am for the petitioner, not they mentioned the matter. But petitioner has challenged not the two orders passed by the Lord executing court by passing directions upon me, the requiring body, by going beyond the decree. My allegation is very specific, going beyond the decree and passing directions on me. I'm not saying in default, stringent action shall be taken against me. Land acquisition reference case, in which section 18 reference amount is enhanced. Direction is passed upon the LA collector to pay certain amounts. I was a party, I was made a party, subsequently added as a party in the reference proceeding. I was a party, but specific direction in the award was against the land acquisition collector. Now, my lord, against in respect of that, they put the, my lord, award in execution, into execution. In execution, my lord, petition, tabular statement, specific prayer is against, my lord, the LA collector. It goes on. Suddenly, my lord, since they are unable, my lord, to get an attachment of the PL account of the state, my lord, suddenly, my lord, a prayer is made that kindly hold the requiring body, the SBSTC, let them produce the, my lord, certificate, particulars of the account, let them pay. I say this cannot be done because kindly, my lord, I'll place two pages. Page 22, my lord. Page 22 is the ordering portion of the, my lord, award by the land acquisition court.
No, Mr. Banerjee, an order was passed on 11th of December 2024,
My lord.
directing you to produce
My lord.
the details
Both
of the
orders-
bank account.
I've
That was
challenged
not
both the
So
orders.
you have not complied with that order. You have not challenged that order also.
Challenged two orders.
11th of December 2024. You are challenging the order dated 14th of January.
Both, my lord. 25 and 26, both I've challenged.
No, what is 25?
25 is 11th of December.
Oh, both the orders you are
Both the orders
challenging.
I have challenged, my lord, on the ground, but my lord, that it is without jurisdiction because court cannot go beyond the decree. These are not settled. I'll just show the decree and the execution.
Yes, show me the decree.
Kindly come to page 22, my lord. This is the ordering portion. Hence, it is ordered that the present reference application is allowed. Page 22, my lord.
The market value such and such. The referring claimants are entitled to the following reliefs.
Following reliefs. Get the following reliefs. Then, my lord, the amount.
Collector upon the collector.
Let the order be sent
Collector
by-
is a party here.
Collector is a party.
Who is appearing for the collector? Yes, Mr. Banerjee, we have not served upon it.
Service.
You have only served the caveator.
I've served the caveator.
Let the collector come.
This is not the order. The kindly come to the execution petition once, my lord.
Yes,
That is
Mr.
not
Mukherjee,
page
how can the
24.
executing court go behind the order?
They have not paid
No, I-
also. Kindly see page
My lord-
24, my lord, the tabular statement.
They are the requiring body, the acquiring body.
The decree is not against him.
The acquiring body is also not taking any steps.
That is a different thing altogether.
And my lord, in compliance to this order, they have already filed their account statement.
They have challenged that order. But Mr. Mukherjee, the basic thing is that show me how can the executing, there is no order or decree against them. But so in an execution, how can they be directed to do something when there is not suffering any decree?
My lord, the acquiring body is the person against whom the decree should be executed.
Yes, you attach the properties, nobody is stopping you from that. But how can the requiring body against whom no decree has been passed? How can an order be passed against them?
My lord, in compliance to this, they have already filed their
They
statement.
have challenged Mr. Mukherjee that order. Maybe they have filed, but they have challenged this order of 11th of
And on
December.
20th July, the next date is fixed for attachment of the PLA account of the acquiring body.
Do that. Nobody is stopping you from that.
Kindly expedites that, my lord.
Do that. But
my
how can
application,
this be done?
Kindly expedites that.
Kindly comes to page 24 once, my lord. Page 24. Column number 10.
Page 24.
24 is the tabular statement. Column number 10. Name of the person against whom execution is sought.
Yes, yes.
Against the
That
state
is
of
there.
West Bengal, represented by land acquisition
Yes.
collector. So they have not even sought it against me. And now they are proceeding against me, forcing me to
No, I am not.
disclose accounts in
I am
default.
not
I'll be.
proceeding against the requiring body.
Court has passed.
I am proceeding against the decree holder.
You are asking for the relief. You are
No,
not.
against the judgment, let us say.
Against the judgment debtor.
Proceed against the judgment.
Against the
Nobody is
judgment
stopping
debtor.
you.
But
How can you ask the requiring body to do
but
something
then
when
I
there is
have
no
to get my relief. I'm 42 years. I am running from pillar to
Mukherjee,
post.
that is neither here nor there. You proceed with that. Nobody is stopping you from that. But how the requiring body?
On 20, that order is not here, no? I am told that on 21st August 2024, the learned government pleader of the district appeared and said that SBSTC had appeared in the trial as well as contested the execution proceedings and the written
Sir,
objection.
Mr. Mukherjee accepting everything. They were party, they contested, they did everything. Show me the degree against them. Mr. Mukherjee, if the decree is not passed against them, even if they have contested, they have done whatever there might be, can you execute against them? Can you proceed against them?
The prayer of the judgment debtor, that a copy of the order was sent to the MD SBSTC for compliance.
Which order?
The decree.
How can it be done? Who has sent that?
Learned executing court.
How can that be done?
At the prayer of the learned government pleader.
Mr. Banerjee, please serve up the state.
Can they do it? Kindly.
Mr. Banerjee, please serve the state. We do not know what is the internal arrangement between you and the state. There must be some internal arrangement between you and the state.
For that, my lord, can the court not go beyond the decree and direct
Let
us?
this
And
please serve upon the state.
Let's have and come back. Kindly,
Petitioner is directed to serve the
On the last occasion, Lord, your Lordship directed us to file a supplementary to indicate
Where
Lord,
is
that.
Mr. Raj?
Yeah. Hey, yeah,
Raj. Have you
That's
notified him?
That's the skill matter, Lord, that we suggested.
Have you
some
notified him?
Yes.
This has been
given an exception to the.
But Mr. Mukherjee, can this be taken up in their absence?
But ideally not, to be very honest.
Because after all,
but they know, Lord, that this matter will be taken up by your Lordship because Lord, today they have given us, Lord, a exception to the supplementary evidence.
They are not here. That's the difficulty. I'm passing it over. If you can bring him, I can take
But
it
we'll
up.
try. Otherwise, your Lordship may kindly keep it, Lord. Tomorrow in the morning, Lord, will come. But we have come up with all, Lord, the.
Rai is appearing in this matter, Ujjwal Rai.
Yes. Mr. Ujjwal Rai, yes. Now you are here.
My lord, he has he's asked me to seek a short passover if possible, my lord.
Short
I
passover.
have not been
Mr.
briefed.
Mukherjee is busy.
My lord.
He has other businesses.
No, there is one, Lord, here.
Then
I'm passing it over if he comes.
If he comes.
Grateful, my lord.
Chakraborty, you are also in this matter.
My lord.
You have not been briefed.
Not yet, my lord.
Not yet. So Mukherjee, please ensure that he is briefed.
But I can give a soft copy, Lord, here and now to him.
Yes.
Grateful.
Call the next matter.
28.
Yes,
28, yes.
Lordship, I am for the petition, Your Lordship. Lordship, the opposite party filed an application on 36 a special marriage and paying for alimony pendente right, Your Lordship. And the learned court bill was pleased to direct me, the husband, Your Lordship, to pay 20,000 to the wife and 10,000 for the child, Your Lordship. Without considering the fact, Your Lordship, three facts have not been considered, Your Lordship.
What is your income?
Your Lordship, the income has not been assessed and the ability to earn. The wife has the ability to earn. That has not been considered, Your Lordship. Kindly turns to the last page, Your Lordship, second last page. The factors are being given to consider, stating the ability to earn. But Your Lordship, that has not been considered, Your Lordship. The wife has enough degrees and also she used to work, Your Lordship. Kindly turns to page number 29. The degree certificate, MTech degree she is having, Your Lordship. Nothing has been considered, Your Lordship.
What are you doing?
Your Lordship, I am a dentist, Your Lordship.
You have a private chamber.
Yes, only private chamber, Your Lordship. No, not attached to anything else. Only private clinic, Your Lordship.
Lucrative practice.
Nothing has been
Dentist.
considered, Your
Yes,
Lordship.
yes.
So income has not been assessed also, Your Lordship. Other costs are there, loan is
Then
there.
the alimony will increase if your income is
Loan
assessed.
also they are kindly
What
considered.
document have you produced for the court to assess your income?
Your Lordship, there I produced income certificate and also my
Income certificate from where?
Income tax return, sorry, income tax return. There I produced, Your Lordship.
Show me your income tax return.
Next here, but I have the copy, Your Lordship.
Show me your income tax return. Where is the assets and liabilities?
Your Lordship, that is annexed, Your Lordship.
Where is that?
Page number 24, Your Lordship. The wife has also the ability, Your Lordship, that should also be considered, Your Lordship. Because I have other expenses, mother is there, Your Lordship, mother, father, and regarding the child, Your Lordship, I am willing to pay, Your Lordship.
Your monthly income is 20,000.
Your Lordship, it is stated here, with all the other costs, Your Lordship, deducting all the other costs.
What is your monthly expenses? What is your monthly
That
expenses?
is not specifically not stated here, Your Lordship.
It's difficult to state. When you have stated your monthly income to be 20,000, it's difficult to state your monthly expenses.
Loan is there, Your Lordship. Kindly consider.
What is the EMI?
Then kindly Lordship, kindly keep this matter tomorrow, Your Lordship. Let me bring all the documents regarding EMI and everything, Your Lordship. Online pray for not today, Your Lordship. Kindly.
On the prayer of the learned advocate for the
Lordship, item number 29, Mr. Devashisha is appearing on behalf of petitioner, Lordship. He is engaged in courtroom number 14, Lordship. Kindly fix it.
pass over. Pass over. Next. Ask him to come. Yes.
Item number 30.
My lord, I am for the petition. My lord, in a execution proceedings, my lord, my vehicle has been attached by the learned court. And my lord, I am neither a party to that proceeding. Now, my lord, your lordship kindly comes to page number 45.
Where is the impugned order?
The order, my lord, since I was not a party to that proceedings, I made an application under Order 21, Rule 58 of the Code of Civil Procedure. That application has been fixed on 25th.
Yes.
Now, my lord, in the meantime, yesterday the police told me to surrender the vehicle. Now, my lord, in the meantime, if they sell my vehicle, my application will become infructuous. Lordship kindly comes to page number 45, my lord.
When it was seized?
The vehicle is still in my possession.
It is in your possession.
It is still in my possession.
So I'm directing the learned trial judge to decide that application on 25th. This application under Article 227 of the Constitution of India is at the instance of the you are the owner.
I am the owner of the vehicle. During the pendency of the execution proceedings, the certificate of registration.
Yes.
Lord, Mr. Kaur had, because he had, no, the tiger is here, my lord, but his senior. Tiger abhi zinda hai.
Yes.
I have a very small and a very short prayer before your lordship. My lord, I don't even want your lordship to get into the merits of the matter. My lord, my in a commercial court, 12 days leave was granted. I filed an application under Order 7 Rule 11 on the ground that, my lord, the commercial court did not have the jurisdiction, my lord.
In Order 7 Rule 11, that is why I said. Again, Order
I
7 Rule 11.
lost. There's no special. There is no, my lord.
That is why my observation, I think I was right in my observation in the morning.
Not right. For a change, my lord, is not correct.
Yes.
But that Order 7 Rule 11, my lord, was rejected. I came up before this honorable court, lost here, went to the Supreme Court, lost there. But the Supreme Court said that all points are kept open.
What all points are kept open? Where? That is in the suit.
That, my lord, the honorable Supreme Court did not, my lord, clarify what points were kept.
Mr. Now what are you on?
Telling your lordship. Now, my lord, that clause 12A, which was allowed ex parte, I have prayed for recalling of that order. Recalling or revocation of that clause, that leave which was granted. Now, my lord, that was not being heard. So I filed another application, and my lord, what they have done is, along with the suit, my lord, they filed an injunction application. In that injunction application, they have also paid for occupational charges during the pendency of the suit. Now, whether that's good, bad, indifferent, the hearing is going on with respect to that.
Injunction.
Yes, I filed an application saying that I have an application which is a sort of a demurrer, which needs to be heard before the other applications can be heard. That application, my lord, is kept pending. And, my lord,
your application is for recalling or revocation of the order granting.
One application is that. The other application is here, that application first. That application, my lord, is kept pending. And, my lord, the Order 39 Rule 1 and 2 application is being heard. I say you can't do that. If I file an application, good, bad, and indifferent, in whichever way, dispose it of. Because I can't, my lord, I prayed for that. The learned judge has only said, keep it on record and goes on.
Show me the
volume. Takes a volume 2, the impugned order.
What is the date of the order?
11th June.
11th June, yes.
My lord, there are 3 applications your lordship may kindly, my lord, look to.
IA number 13.
And the action. My lord, the application which I want, my lord, the learned judge to dispose of.
No, this was fixed for hearing of 13 of 2023.
Yes, my lord. 13 of 2023, my lord, is the application for occupational charges.
That you have filed.
They have filed.
Oh, you are the plaintiff.
I am the defendant.
This is 13 of 2023 is filed by the defendant.
No. It is an application which is filed, my lord, by the plaintiff for occupational charges.
It says hearing of the on behalf of the defendants. Order records that.
That's an incorrect statement. That's it. 13 of 23. কোনটা জজ সাহেব দেখছেন?
No, 11th of June 2025 order.
No. My lord, it was fixed on 16th of June. Accept. For further hearing of IA number such and such on behalf of the defendants means, my lord, we will have to submit. We will have to submit on.
Hearing of IA on behalf.
My lord.
All right. Yes. So you will make submissions.
Yes, my lord. I have said, kindly have a look at the IA number 29 of 2025, which, my lord, has been kept on record, which your lordship finds on the 4th paragraph. Plaintiff has filed affidavit in opposition to the application being IA number 28 of 2025. Copy served, let it be kept with the record.
Yes.
And then
this is the application for taking up that 12A revocation.
Yes. First.
Yes.
And it satisfies my lord self at 241. And then your lordship will see, my lord, it's at 243. And my lord, the prayer portion, your lordship will find, is at page 246. I am saying dispose of this application, nothing else. On the next day, my lord, after disposing of this application, the learned judge may, my lord, carry on with the hearing if he so feels.
What is the difficulty, Mr. Chatterjee, if the injunction is hard?
My lord, the injunction will go if the leave is recalled. My lord knows, my lord, that Order 12 Rule A is a mandatory
Leave has
provision,
been granted.
and I'm challenging that.
When the leave was granted?
Before the Order 7 Rule 11 application.
Commercial Code Sector 2.
Before the Order 7 Rule 11 application.
It
Ex parte.
was in 23. I'll show that, and I'll show, my lord, why this is clearly barred by res judicata and what played on the mind of the learned.
My lord, if my learned friend wants to, my lord, argue on merits on clause 12A, I have no problems. I'll argue it
I'll
before your
only show that this is clearly barred by res judicata because they have urged this in the Supreme Court. It has been considered and rejected.
Now, that's
same issue
probably
has
not a
been
correct
raised upon. I'll indicate from the documents.
Not a correct statement. Not a correct statement. And even if it has, my lord, that's on merits. My application cannot be kept pending. This is an interrogatory application. The suit can't be entertained without a 12A. It's mandatory. And when it can be granted, my lord, in a very urgent situation, this is a suit for eviction.
But once my learned senior friend has made his submission, I'll indicate
Then
5
kindly relax then. Then relax.
Take your seat,
Don't,
take your seat.
you will submit. Nobody is going
Yes,
to
Mr.
stop
Bhatt, take
you.
your seat. Yes.
Now, my submission, my lord, with respect to this is very simple. I have filed good, bad, indifferent an application saying that hear my application first. Now, what happens in an Order 6 Rule 17 situation and an Order 7 Rule 11 situation? Law is very clear. You will have to hear the Order 6 Rule 17 first and then go on to hear the Order 7 Rule 11 because it goes to the root of the matter. Now, here is the case, my lord. I am saying, hear my application, which asks you, rather a praise before you, to consider whether you will hear my revocation application first. Nothing more than that. Today, whether, my lord, it will be recalled or not, is not the subject matter before your lordship. Whether it's barred by res judicata, whether it's barred by Order to Rule 2, whether it's barred by whatever it is not the subject matter before your lordship. That's the subject matter, my lord, when the application is going to be heard. So today what happens is, my lord, if the Order 39 Rule 1 and 2, my lord, is heard, some order is passed, and then later, my lord, the order is recalled, then the entire exercise becomes futile.
Mr. Chatterjee, they have made their submissions on the injunction application.
Yes, my lord.
You make your submissions. What is even if an order is passed and 12A that leave is recalled, that order will go.
I am very well.
What is the difficulty in that?
My difficulty is that, my lord, I am.
How many days? Because they have made their submissions.
Yes,
what is the next date fixed?
Tomorrow.
Tomorrow.
Let my application be heard first and then after the Order 39. I don't have a problem. On the same day, if my application is heard.
Mr. Chatterjee, the difficulty is that tomorrow is fixed for hearing of the injunction application.
Can't happen. That's the anomaly.
Yes.
Can't happen. You can't keep an interlocutory application pending and say, I will hear the final suit.
This is not the final suit. That is also an injunction. That's an urgent relief also.
That's exactly what my submission is before your lordship. If it's an urgent relief, I would have understood. It's not an urgent relief.
Injunction is an urgent relief.
This is for occupational charges.
No, you said injunction application.
Injunction with the prayer is occupational charges.
Where is that application?
Yes.
13 of 2023.
Yes, sir.
35.
35.
Only 35?
Yes. Unfortunate.
Page 51 is the prayer.
And turns to 51 thereafter.
51 is the prayer?
Yes.
Longish application.
Malo.
35, 51.
Malo. It's a 44-page application, 44 para application, my lord, where mostly, my lord, it's
Oh, I was thinking that it's an injunction.
No. No.
Yes.
So there is no pressing urgency, my lord, that an injunction application that I am selling off the property and running away. No. He wants occupation charges during the pendency of the suit. Whether that's maintainable is a separate aspect altogether. My lord, there are divergent opinions, my lord, of this
That is
court.
your application.
My lord. 241. And I'll preempt their submission, my lord, with respect to res judicata, because they've my lord, made a lot of.
51 is your application.
Yes, my lord. And cease 246. 246.
Adjourn the hearing of Atto and fix the date of hearing. Where is 28 of 2025?
112. This is the revocation. Prayer, my lord, your lordship will find
112.
at 118.
Where is the order dated 1st of April 2023?
Yes. Page 66. Kindly comes back to page 66.
66.
And sees the urgency, my lord, is taken care of at page 72, where the injunction was granted. And sees page 66, my lord.
Where is the leave granted? Which page?
Can you see page 67? First is 66.
No,
With this
66 is the order
item
thereafter.
number 1 of 2022 is the clause 12. Then turns to 67.
Yes.
After learned counsel, Mr. Shuddhashatya Banerjee, the 12A, my lord, paragraph, your lordship need not trouble my lord self. Then, I have heard the submission is made by learned counsel in respect of the present application being number such on great length and perused and considered. Mr. Banerjee, as regards, comes down. On prima facie contemplation, it appears that the suit contemplates an urgent relief by filing necessary application under Order 39 Rule 1 and 2 read with Section 151. Therefore, the leave as sought for by the plaintiff in the instant interlocutory application is granted. Accordingly, the instant interlocutory application is hereby disposed.
Yes.
I am praying for recalling of this part of the order.
No. So, which order was challenged before the Supreme Court?
Milord, the Order 7, Rule 11 application. There, kindly
Thereafter,
takes
you filed an application under Order 7, Rule 11.
Rule 11.
Where is that?
That Order 7, Rule 11, Milord, takes up the judgment.
Yes, the order.
My lord. Kindly takes it up at 154. Here, my lord, I
154
will-
is second volume.
Yes, Milord, second one. Kindly sees 156. I'm sure my learned friend, Milord, was eager to show your lordship this, if I'm not mistaken.
150?
156. My gamut of Order 7, Rule 11 was that the dispute with respect to, my lord, the in the suit was not a commercial dispute. That was Order 7, Rule 11. Kindly sees paragraph 7. The petitioners also raised a question with regard to the maintainability of the suit in the commercial court on account of non-compliance of Section 12A of the Commercial Courts Act. It was submitted that mediation had not initiated by the plaintiff opposite party. Then turns over 157. Just before paragraph 10 starts, exemption from applicability of Section 12A. My lord, kindly got it, Lord? Of the Commercial Court.
Yes.
Exemption from applicability of Section 12A of the Commercial Courts Act was paid for, and such leave was granted by the court by an order dated April 1, 2023. So that order was not challenged, my lord, in the order 7-11 at all. This was something which I pointed out. My lord, here, after the revision application was, my lord, dismissed, we went, my lord, to the Supreme Court. 163. I'm sorry, my lord, kindly have a look at 163 also. That's the next place where, my lord, the 12-A leave, my lord, was sought for. I mean, it was not sought for, was expressed. Kindly see paragraph 17. 4 lines from the top. The leave under clause 12A was paid for and was allowed by the court.
Yes.
Then, my lord, kindly have a look at, I'll be very candid, whatever about 12A before the court during order 7-11, my lord, I'll show your lordship. Looks to 185. And sees paragraph 5. Though I feel, my lord, at this stage, this is a waste of time, but even then, my lord, I want to satisfy my lord's conscience.
No, this is the special leave petition.
Yes, my lord. We had said about 12A, my lord, I want to show, and what we have said, I want to show. The learned trial court granted leave to the plaintiff under Section 12A of the Commercial Courts Act, which is dehoused the provision of 12A, and there was no emergency as contemplated in Section 12A in the matter for suit for eviction.
183. Mr. Chatterjee is 12A.
No, I don't want your lordship to look into the merits.
12A, leave is to be granted after hearing the other side,
There has
or it
to-
has to be an ex parte one.
My lord, it has to be, my lord, in my respectful submission, can be both. Can be both. Can be both. Can be ex parte as well. Ad interim order of injunction. It is ex parte. I am not saying that it could not have been granted. But I will also have a right to show, my lord, like order 39 rule 4, I will also have a right to show that, look here, the grant which was granted was wrong. My lord, in a section 80 suit,
I was thinking of
my
that.
lord, in a section 80 suit,
Yes.
Leave under clause
same thing, leave under clause 12. Absolutely. I am not for a second saying, my lord, the court doesn't have the power to grant. I am saying, my lord, that the grant was wrong. And then, my lord, the Supreme Court, my lord, I'm a little happy with the appearance. If I have lost, he's lost too. No merit, same is dismissed. It is made clear that we have not pronounced on the merit of the suit for either side. So, I don't think, my lord, Supreme Court rejected my prayer under 12A or something. I am not sure, my lord, subject to correction by my learned senior friend in the other side and by my lord. So, res judicata will apply only when, my lord, there has been an adjudication process which has been undertaken. With a lot of respect, here there was no adjudication with respect to recalling of a leave grant. No adjudication. 1. I am not praying for an adjudication before your lordship today. Kindly keeps it in mind. I have only said that please hear my application. Before you go on with the hearing of the, my lord, the injunction application where you have only prayed for occupation charges. Now, what is the modus operandi is nowadays, file a suit for eviction, filed an application for occupation charges, get an order there, bombard with the money, run away. Lord, that submission, of course, Lord, I'm sure it's going to come back to your lordship on that, but I'm not making that submission here. I will show your lordship, Lord, that under order 39, the division bench says it's not maintained. The application itself is not maintained. But under order 39, I am not even making that submission, my lord, before your lordship, because I feel your lordship is not hearing the injunction application, nor is your lordship hearing, my lord, the section 12A revocation. Your lordship is only hearing whether the application I made, that please hear this application first, before you complete the hearing of the order 39 rule 1 and 2, hear my application and pass an order. If I fail, I'll come back to your lordship. And if I pass, they might come back to your lordship. I am only on that. It's a very simple point of law, my lord. Order 6 rule 17, order 7 rule 11 situation.
Anything more?
No. No, this is on merits. Why will I accept their submission?
Lord, kindly take the list of dates. I just take your lordship 2 minutes through the list of dates, which is at page 193. This is their list of dates, Lord, which is annexed to the SLP.
193.
Yes, starts at 193. I just skip over the dates quickly. Lord, 1973 is the first date. Has your lordship got that? 193.
Yes.
A lease was executed. They were inducted as a lessee in respect of a property. Now, Lord, 93, that lease expired. This is premises number 195 Picnic Garden Road. Lord, it's a I think 2 bigger something property with a 2-story house. Then 93, the lease expired. Kindly, Lord, come to 10th April 2003. They applied to the Thika controller for declaration that they are a Thika tenant. Now, Lord, this declaration was granted by the Thika controller. Lord, kindly
2012. 1st of August 2012.
1st August 2012. Yes. Then, Lord, your lordships will find that this was affirmed by the West Bengal Land Reforms Tenancy Tribunal. The challenge of declaration was affirmed. Then, Lord, we came to the High Court. Then, Lord, the High Court, Lord, rejected these 2 contentions, the earlier 2 orders of both of Land Reforms Tenancy Tribunal and, Lord, the Thika controller. Matter traveled to the Supreme Court.
Ultimately in review.
Ultimately in review.
Right law came.
Now, Lord,
the right law came.
Right law, wrong law, whatever came in. Now, Lord, we file a suit. After all this, Lord, we file a suit for eviction. Now, your lordships will kindly come to the next order. Your lordships will kindly come
2023, you filed the suit.
2023, Lord, 2022 is the final decision of the Supreme Court. 27 July 2022 is the final decision of the Supreme Court. That is page 197. That review application, after it being recalled, ultimately it was reheard and this is allowed. Then, Lord, I file a suit on 30th of March 2023. Then, Lord, an application on we file an application for dispensation of 12A. And we also file an application under Order 39, Rule 1 and 2. Then, Lord, the Learned Commercial Court on 1st April 23, your lordships will find that also by allowed, Lord, dispensation of 12A and passed an ad interim order. This is on 1st of April 2023. Then, Lord, the petitioners, Lord, filed a counter suit 469 of 2023. This is, Lord, a suit for declaration that they are in adverse possession. They were so long Thika tenant up to 2022. After 2022 adjudication, when my right to sue is restored by the Supreme Court, I come and file a suit. Then, Lord, a suit for adverse possession. Then, Lord, kindly come to the page 200, 11th April 2023. They file an application under Order 39, Rule 4. Has your lordship found that? Then, Lord, an Order 7, Rule 11 on 4th of May 2023. Now, Lord, this ultimately went to the Supreme Court. Your lordships will, Lord, I skip all this. kindly come to page 203. There was an order passed by the High Court upholding the rejection. From that, the matter goes to the Supreme Court. Now, my lord, kindly see, I don't want to take your lordship to other pleadings. Only, my lord, SLP, please come to page 185.
180.
185.
185, yes.
No, please.
Yes.
185. Kindly, my lord, come to 5. The learned
Yes.
trial court ex parte granted leave to the plaintiff under section 12A of the Commercial Courts Act, which is dehors the provisions of 12A of the Commercial Courts Act. Then there was no emergency as contemplated in section 12A, the matter of the suit for eviction. Then, Lord, please come to page 232. This is, Lord, ground number 5. This is, Lord, questions of law, starts at page 231. Kindly, Lord, see the questions of law, ground number 5. Whether leave could be granted under section 12A of the Commercial Courts Act. I'm sorry.
Yes, yes, I've seen that.
2015 in a suit for eviction when there is no urgency. Has your lordship found that? Then, Lord, please come to page 233. Grounds. Ground B. For that, the Calcutta High Court failed to appreciate provisions of the Commercial Courts Act 2015, especially section 2 of section 12A of the said act. Now, my lord, why this ground was taken? Because, my lord, 12A point was categorically raised, but the High Court did not deal with it. Your lordships will kindly get that from the order of the revisional court that your lordships will find at page. Yes.
This 12A point was raised in Order 7, Rule 11.
Yes. Not at the trial court stage, but not when they came under 227. When they came under 227, challenging the rejection of Order 7, Rule 11, this point was categorically taken. Your lordships will kindly find this from the judgment, Lord, at page 154. Kindly, Lord, come to page
154.
Yes. The judgment starts at
Yes,
page
yes.
154. Please come to page 156. Paragraph 7.
What's the decision on this?
No, there was no finding on this because I tell your lordship, this point was not raised in the application under Order 7, Rule 11. So, my lord, the court, 227 court did not give a finding. Your lordships may kindly see page 157, paragraph 9.
Yes.
163. Sorry.
163.
Kindly, my lord, take paragraph 17. This is the
Paragraph
17. 17.
Page 163.
163. Paragraph
Yes.
17. Your lordships may kindly see the plaintiff discloses a cause of action for suing the defendant. The reliefs are in consonance with the cause of action, namely recovery of possession, mean profit, etc. The calculation of mean profits have been provided in the plaint. There are averments with regard to the valuation. The leave under clause 12A was prayed for and was allowed by the court. The pleading that the suit was not barred by limitation is available in the swans. So, my lord, this is what the finding was. So, there was a specific ground taken. That, Lord, your lordships may now kindly come back to the ground at page 233. Your lordships will find this ground was taken. Now, my lord, interestingly, after the SLP is dismissed, what they do is they come and file an application under Order 7, Rule 10. For return of the plaint on the ground that this is not a commercial cause. This point was raised in Order 7, Rule 11, rejected by the court, rejected by the High Court, rejected by the Supreme Court, then Lord, Order 7, Rule 10. Both, Lord, 12A point was raised in the Supreme Court. Well, 12A point was also raised in the Supreme Court. After rejection, they come and file an application under Order 7, Rule 10. Then, Lord, what we do, we file an application under Clause 13 of the latest patent for the two suits, our suit and their suit
Club
to be
together.
tried together. Our High Court, my lord, passes an order clubbing the two suits and saying that the two suits should be taken up together. So that their suit is transferred to the commercial. And my lord, in the commercial court, the day-to-day hearing is happening because of the directions given by the High Court. Kindly, my lord, have a look at that order passed by the High Court. No, that order is not here. I'll just hand up the order. Yes. Lord, the day-to-day hearing is pursuant to this order. Now, Lord, what happens is that our application for occupation charges that was fixed by the Supreme Court at 1,50,000 per month, that was paid, Lord, during the period the matter was before the Supreme Court. Now, Lord, once the matter is disposed of and the suit is filed, they are not paying any occupation charges. They are enjoying the property free of cost. So, Lord, we file an application for occupation charges. The entire fight is with regard to that. They don't want that application to proceed. So, Lord, one after the other. First, Lord, Order 7, Rule 10, that is also rejected. Now, Lord, an application under Order 7, Rule 11 on the self-same ground that liberty, that leave granted under 12A was not in accordance with it. Now, Lord.
But Mr. Kaur, only one thing. Was there any decision on the prayer that leave under section 12A was not rightly granted or it was not granted? Because Order 7, Rule 11 application, that was not the point.
Yes.
Civil revision, they have raised a point and it was finding is that leave was sought for, prayer was allowed. That is the only finding. That's the finding on fact because it will appear from the order that leave was sought for and prayer was, and that was allowed. But can an application for revocation of that order be not filed?
Lord,
or was there any decision to show no, that leave was rightly granted?
Lord, the issue is that, Lord, the leave order was granted on 1st April 2023. Thereafter, they were served with the writ of summons. They filed their written statement, and then they, Lord, came with an application under Order 7, Rule 11. Now, Lord, a point which could have been taken ought not have been taken, or Lord, a point which is taken before the Supreme Court. Lord, how many times
in the written statement did they take this point of section 12A?
No, they have not. But in fact, kindly see page 234 once again. Your lordships will find ground E. There is no pleading as to how the suit comes within the purview of Commercial Courts Act and in view of the provisions of the Commercial Courts Act, especially.
But the only difficulty is that SLP was rejected. So whether
the speaking order, SLP was rejected, not one line order. Kindly, my lord, have a look at the SLP's order. Kindly, my lord, see the order of the Supreme Court. Yes. So please come to paragraph 2. We have perused the pleadings in the plaint and also the reasons why the applications filed by the defendants under Order 7, Rule 11 was rejected by the court. Having considered those, the specially petition is found to be devoid of merit, the same is dismissed. It is made clear that we have not pronounced on the merit of the suit for either side.
Yes.
Pending applications shall stand dismissed, shall stand closed. Specially petition is devoid of merit. That means, Lord, all points taken in the SLP goes. One just can't come up and, Lord, go on doing it. Lord, the issue is, Lord, how many times, Lord, we have to meet a point. And, Lord, they have filed this application on 10th of June. While, Lord, the court was in the midst of hearing that the occupational charges application. They have not also placed their application under Order 39, Rule 4. And Lord, there is a reasoned order. Page 66, your lordships will find there is a reasoned order passed by the court while granting leave. And in fact, the occupancy charge application is nearing conclusion. Kindly, my lord, see, this is the dispensation. Page 66, the order starts.
Yes, leave is page 67.
Yes, IA number 1 of 2022. The urgency, my lord, it says on prima facie contemplation, it appears that the suit contemplates an urgent relief by filing necessary application. Therefore, the leave as sought for by the plaintiff in this instance, the interrogatory is granted. Accordingly, instant interrogatory application is hereby disposed of. And then, Lord, the court proceeds to consider Order 39, Rule 1 and 2, and Lord grants an interim injunction.
Where is Order 39, Rule 4?
Order 39, Rule 4.
Application.
Application. দিয়ে দাও না, হাতের কাছে থাকলে দিয়ে দাও. It's also pending. That is also pending. Order 39, Rule 4, this point is not taken. Order 39, Rule 4 is taken, you couldn't have passed an interim order. That should be vacated. That is the ground, not on the ground of 12A. Look, what is the position? Look, they were commercially exploiting the property. And Lord, they had given it to BevCo, earning a rent of 19 lakhs and odd. We made an application to BevCo, and those are on record. BevCo gave a reply. Now, Lord, BevCo vacated the property, and there was a chance that they would again, Lord, commercially exploit the property. Therefore, Lord, this application was moved under Order 39, Rule 1 and 2, saying that they should be restrained from utilizing the property. And Lord, that is, kindly see the order that was passed in Order 39, Rule 1 and 2. Kindly see page 72. The first paragraph.
Yes.
Lord, there is a long history of litigation. And Lord, the suffering of these owners are immense. Lord, this is the reason why, Lord, the emergency clause was invoked. And Lord, what will transpire in this, even if we go for a conciliation? Lord, in this long line of litigation, starting from thicker tenancy to adverse possession.
But that's the statutory mandate.
I'm saying, Lord, 12A dispensation was obtained legally upon a valid ground. And Lord, the urgency is...
Is there any provision to recall that? Can that be recalled once the leave is granted?
There is no provision, but Lord, if the court feels that, like, Lord, there are judgments now that has come up, party automation and the subsequent judgment, where the suit was filed, but Lord, without any application.
That is a different thing altogether.
And now it says that Order 39, Rule 1 and 2, even if the court does not grant an order of injunction, it does not mean that the suit, the leave should be revoked or the suit should be dismissed. It says that it will depend on the facts and circumstances. Therefore, Lord, I am not averse to the fact that, Lord, this is an absolute abuse of the process of court. That is the reason, Lord, why I am bringing it to your Lordship's notice. This absolute abuse of the process of court. Starting from 2003, this litigation is continuing. And therefore, Lord, the whole exercise is somehow to stall that application and to bring in Order 7, Rule 11 gone, so Order 7, Rule 10 gone, now another Order 7, Rule 11.
Where is the order passed on Order 7, Rule 10?
Rule 10, Order 7. Commercial court. Lord, this is dated 15th May 2025.
Not any.
Not. 15th May 2020. Order 39 application at copy also.
No, this was fixed on 19th of May for passing orders. What
19th May. That very next order. I'm sorry. I gave your Lordship the wrong.
Yes.
And Lord, this is the application under Order 39, Rule 4, my Lord, to permit us. There's
That
no
point was not taken.
No, it's not taken.
Can you give me this order of 19th
Yes,
of
yes. I will just take it out from the punch and give it to you. Lord.
Anything more?
No, Lord, I just, Lord, want to say one thing. Lord, if this is, Lord, an absolute abuse, and Lord, there has to be a finality. They, Lord, just can't go on, Lord, litigating on a point which they have raised and they have either not praised, or even if they have praised, that has not been considered by the Supreme Court. Now, Lord, that has attained a finality. There can't be, Lord, litigation, re-litigation. Lord, I can take this point. I've argued there, but not considered. There is no finding, therefore I come. That's not the point. Point is that if you have taken a point, and whether you argued or not argued, matter stands decided. It's finally decided. So, Lord, there can't be a re-agitation of this point. These are, Lord, my humble.
So, if that is your argument, so that application praying for revocation is liable to be rejected from here. Because according to Mr. Chatterjee, that he has rightly or wrongly filed an application that requires to be adjudicated. So if your submission is accepted, that issue of 12A has been already decided,
yes,
and that's res judicata, there is no necessity for deciding that application. That should be rejected then and there.
Lord, that is my first submission. That I say that because I have shown your lordship from the pleadings that this was taken not only, Lord, in the synopsis, grounds, question of law, every aspect this point was raised.
Yes, so there is no necessity for deciding that application.
Application again, once again. That is my point. And I say this, Lord, that there has to be a hiatus to the questions being raised. That I file an application under Order 7, Rule 11, I don't raise that point. I file an application under Order 39, Rule 4, I don't raise that point. I file an application under Order 7, Rule 10, I don't raise that point. I raise that point only when the litigation comes to the High Court and to the Supreme Court. And Lord, I don't get a judgment from there. Therefore, Lord, to stall the proceedings, I can again file an application. This is, Lord, a clear abuse of the process of court in my humble submission. This can't go on.
Anything more?
No, Lord. This.
Anything in reply, Mr. Chatterjee?
I'm praying for leave, my lord, for two things. One is a question fell from my lord, whether it can be revoked or not. Our High Court has held that it can be revoked. It's the judgment of Justice Krishna Rao, my lord, in Perfecto.
Electricals and others.
Perfecto Electricals and others versus Rail Vikas Nigam Limited. This is CS
You
Commercial.
give me that judgment, but Mr. Kaur says he is not joining an issue on that.
Then
to
I'm
him,
not submitting on this. Then I'll answer to
give
what.
me the copy of that.
I'll do that.
But
Just give me
according to him, that issue has been decided
I'll answer
one way or the other.
I'll answer that.
And that is SLP dismissal was not a non-speaking order.
I'll answer
It
that.
was a reasoned order.
I'll answer.
Lord, if your lordship wants, I can give that judgment. I don't have the judgment. I'll give it to your lordship, Lord. That judgment that once the SLP is decided, point is taken and the SLP is decided, it brings about a finality so far as the matter is
So the
concerned.
principle of merger will apply.
Will not
If it is, even if it is special petition, if it's by a reasoned order, that's the distinction.
That's a distinction. If it is mere dismissal, that's another question.
Lord, if your lordship has may I just answer my learned senior friends, my lord? According to me, as I have read that SLP, my lord, if that is a speaking order, my lord, then in my respectful submission, my lord, the definition of speaking order has changed. There is no reasoning as to why the lordships feel that it doesn't require, my lord, an interference in special leave petition. So as I read it, my lord, and in my respectful submission, it was not a speaking order. If it was a speaking order, my lord, then there had to be a reason why and what. But there was nothing of that sort. The Supreme Court can, under 142, just reject it. If it just rejects it, my lord, there is no merger. The Supreme Court says
that's the distinction.
My lord. It says that I can file a review application as well. Now, the question is, my lord, they are going on harping that this question of revocation, my lord, has been taken up everywhere. May I ask this question to myself, where is that adjudication? 12-year leave was granted. The order, my lord, which granted leave was never under challenge.
Your grounds.
My ground, my lord, I have
that
stated
leave
a fact.
would not have been,
my lord.
That issue that you have challenged. That is Mr. Kaur's submission.
I have made. That is not a challenge.
You have raised that point.
Raised the point, I have said it could not have been done, but it is not a challenge. That order which passes, my lord, the leave was never under challenge. In order 7 rule 11, in revision, in Supreme Court, the order which grants the leave was not under challenge. If something else was being done, which was done wrongly, I have said this is done wrongly. That's it. And if this is res judicata, my lord, then again section 11, my lord, is out of the civil procedure code. One aspect of the matter. The entire argument of my learned senior friend is, as it fell from your lordship, rejects that application, need not be heard. So if it is the law, my lord, that an application which is filed, which is interlocutory in nature and which is a demurrer in nature, my lord, that it need not be heard at all. My lord, the Supreme Court, if my learned senior friend grants me leave, the Supreme Court says that if it's a jurisdictional issue, it has to be heard at the initial stage. This is, my lord, 2024 4 SCC 696. I'm sorry, I ought to have cited this earlier, my lord, but this submission once made, my lord. Have a look at paragraph 49 and 50. I am not going to read it out for your lordship. Have a look at 49 and 50. If I'm not mistaken, it's authored by Justice Dr. Yes. See, it's the last line. Needless to observe of paragraph 49. Needless to observe, the question of jurisdiction has to be determined at the commencement and not at the conclusion of the inquiry. I am not even, my lord, all these submissions which have been made by my learned senior friend is on merit of that application. That application was never heard. These are all arguments which I would have met if the application was heard on merits and disposed of. Heard and disposed of. I'm on that. Lord, I ask this question to myself again. Where is the adjudication on recalling?
Yes.
Lord, simple, Lord, my respectful reply, Lord, to my learned senior friends' submissions. All those submissions are on merits of that application. Then your lordship, Lord, would hear it for the first time, the application before your lordship. I'll make my arguments, my lord. If this is what it is, Lord, the law gives me a right to file an application. If I have a right to file an application, my lord, I have a right to have it heard. And I have a right.
Give me that judgment, that revocation of section 12.
Yes, but we'll just get a printout and give it to her. It's perfecto. Perfecto.
Citation.
It's citation.
Please give me that. Mr. Kaur, anything to reply on these decisions? Not on facts.
It is a reported decision, my lord. It is 2025 SCC Online, Calcutta 3996.
Give me a copy of it.
I'll immediately.
What is the reference, please?
Yes, 2025
2025
SCC Online, Calcutta 3996.
Yes.
Lord, the latest judgment of the Supreme Court on 12A is Dhanbad Fuels. I'll give your lordship a judgment, copy of the judgment.
Dhanbad to Delhi te kabe kana?
This is the last judgment of Justice Padiwala. Hey.
This is on
12A. This is on 12A. How it is to be dealt with.
Which paragraph?
Lord, your lordships may kindly follow paragraph 62 and 63. Conclusion. Your lordships will kindly come to the conclusion. Lord, please come to paragraph 62, where the ABCD is set out.
Yes.
Page number name?
Page number is 41.
Yes. Kindly, Lord, the
41,
and
page number is 40. You wanted to know the page number?
no, my lord.
All right.
This
Yes.
is again F. Kindly see F and G.
Yes.
The test of urgent interim release on the examination of the nature and subject matter of the suit and the cause of action, the prayer of urgent relief by the plaintiff could be said to be contemplative, playable, when the matter is seen from the standpoint of the plaintiff. Courts must also be wary of the fact that the urgent interim relief must not merely be an unfounded excuse by the plaintiff to bypass the mandatory requirement.
There you go.
This is the only test. And Lord, here the interim order has been passed by the court, considering the interim urgency.
Exactly.
H says that even if the interim relief is declined, the suit can't be dismissed. Can't be said that there is no urgency. And also take note of D, paragraph 62D.
62D.
D.
Yes.
Say, a suit which contemplates an urgent relief may be filed under 2015 Act without first resorting to mediation as prescribed under section 12A of 2000.
That is for what you want. We wanted leave.
Correct. And that is why we filed a separate application. This judgment, of course, says no separate application is necessary. On the basis of the plaint, this can be done.
Unlike section, that's the distinction. 80 subsection 2 leave of the court is not required to be obtained before filing a suit without complying with section 12A. So that's a distinction made.
Correct. But when the suit was filed, then this judgment was not there. So an application was filed seeking dispensation of 12A.
Sees A.
Yes.
After my learned senior friend finishes. I just have a reply on that.
Yes.
Again, this judgment is on the merits of 12A. First paragraph, my lord, is that this is mandatory.
Yes, yes.
He have applied, he has granted. I have a right to show that the grant was wrong. I am not saying anything else, my lord. I am saying I have a right to show that the grant was wrong. And that is G. And I need an adjudication on that, nothing else. I am not asking your lordship to allow my application from here. C is G. I am saying the court has gone wrong there. And I want to show the court that the leave which was granted was wrong. I am not saying, my lord, that the court can't. I cannot say.
Mr. Chatterjee, what is your ground under 12A?
There was no urgency as such.
Yes.
So it had to go to first mediation and then come back.
Yes. But an urgent relief, urgent relief, interim relief was granted.
I have an order 39 rule 4 pending.
That is still pending.
Yes, my lord.
That is still pending. Is it your ground that section 12A was not, leave was not rightly granted?
This is my ground in this application, which is pending.
Order 39 rule 4.
No, order 39 rule 4 was with respect to the injunction granted.
Yes. So injunction according to you, there was no urgency.
I'll tell you, lordship. But I'll explain this. With respect. আমি বলিনি শেষ করে দিন নাহলে আবার কালকে my order 39 rule 4 application was one part. What happens is if order 39, even if the leave is not granted, the suit is not dismissed.
No. That is.
So that it's a different aspect altogether. I am saying a process has to be found out. Pardiwala says partial automation is correct law. Says it's mandatory. So it has to go for mediation. Lord, if
that
you have
is why
chosen,
they have fought for leave.
Correct. Lord, that is exactly I'm saying.
You, leave could not have been granted.
Could not have been granted. Not could not. Should not have been granted. So my application is basically that. Today, my lord, that application has not been heard. Whether G applies or not, that the court needs to first decide. And then I come back to your lordship on that decision. Today, that has not been done at all.
Yes. Give me that judgment.
Yes.
When you will give me? Tomorrow.
Tomorrow. I can give it to your lordship within 10 minutes.
So I'm keeping it to be mentioned tomorrow.
Very good.
And this judgment has no manner of application. 4950, I am also relying. Your lordship will find there the decree was passed and a point is taken that the court has no jurisdiction.
Heard Mr. Chatterjee, learned senior advocate for the petitioner, and Mr. Kaur, Learned Senior Advocate for the opposite party. First up, list this matter tomorrow under the heading to be mentioned to enable Mr. Chatterjee to file
To hand over the judgment.
to file a copy of the decision which Mr. Chatterjee relied in course of this.
Automation.
In course of hearing of
Exactly. Absolutely. Absolutely.
I accept that proposition. It is by way of Order 7, Rule 11. Revocation means not as a revocation. It has to be by way, that is party automation, which is affirmed here with certain other guidelines which is given by the party, Justice Party.
Yes.
Order 7, Rule 11 is the way out. The Order 7, Rule 11 is the revocation is by way of Order 7.
Order 711 cannot happen here.
This is what party automation says. It's not my saying.
Subject
to yes.
The other matters Lordship will take up tomorrow.
Yeah, continue.
Yes, where is your other side?
was
Could not
there.
find your other side, Mr. He has left.
Tomorrow at 2 o'clock. Lord, he has requested tomorrow in the morning, Lord, he has some difficulty Lord, at 2 o'clock.
What is the right time?
298. 298, mark 2 p.m. today.
298 ta kalke 2 p.m. dekha. 29 passed over
Passed over matters, your Lordship will kindly continue tomorrow.
after the freshman.
Double free.
It will remain in the list. It will be taken up.
Your Lordship, kindly that order I couldn't finish that day, Your Lordship, on Wednesday during the time of mentioning, Your Lordship.
Yes, what do you want?
Your Lordship, to be mentioned or
why?
Your Lordship is
once adjourned, once you have got chance.
kindly, Your Lordship.
Item number 20.